Oh, yeah, yeah.
Hey, good evening and welcome to the April 7th meeting of the Falmouth Zoning Board of Appeals, calling the meeting to order, and we'll ask everyone to please silence their cell phones at this time. I'll introduce the board, starting at my far right. Your far left is Jerry Patamas, who is an associate member of the board. To his left is James Morse, who is a full voting member. To his left, my right, is Scott Zelinski, who is the board's vice chair. My name is TJ Hurry, I'm the chair of the board. To my left is Bob Dugan, who's the board's clerk, and followed by him is Scott Peterson, who is an associate member. Also with us tonight is Noreen Stockman, who is the zoning administrator, and Ashley DeMello, who is the recording secretary for the night. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town, and we consider requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. All decisions the board makes are made through the public hearing process. The board's goal is to hear testimony from the applicant, from the public, and also to allow a full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and then present any pertinent information from the file, such as referrals from town departments and summarizing correspondences to the board. The applicant or the applicant's representative will then have 15 minutes to make a presentation, and time may be extended by vote of the board. The board will then question the applicant, and the public will then be invited to comment as well. Public comment should only be directed at the project itself. We ask you to please refrain from making any personal or derogatory statements. Public comment can include opinion in favor, in opposition, or it might just simply be a question about the nature of the project. The chair will limit discussion in the interest of time in the event that comments become repetitive. All members of the public wishing to speak should wait to be recognized by the chair, come to the podium to your left, and we ask you to please state your name and address for the record. We do limit public comment to 2 minutes per person, and while everyone is speaking tonight, we ask you to please remain behind the podium and speak into the microphone. Microphones that we have in this room are not meant for amplification. They're for the benefit of everyone watching at home on FCTV. We will then either close or continue the hearing when the board is satisfied that enough information has been presented by testimony and in the file to make a decision. By motion and vote of the board, the hearing will be closed. In the alternative, we may continue the hearing to a future date and time certain. After the hearing is closed, no more testimony may be taken. As for board discussions and decisions, the board may then further discuss the project among ourselves. We would make a motion to deny or approve that would be made and voted upon. Motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approvals of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, would be a failure to carry and would result in denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. According to our agenda for the night, we do have public comment, followed by 2 continuations, 4 new hearings, and a few items on our open meeting agenda as well. So up first is public comment. This public comment period is meant for anything that is not on the agenda. So if you're a member of the public wishing to speak on a project, just sit tight for the appropriate time in the evening, and we will get to that point eventually. But for now, is there anyone out there with anything to say on something that is not on the agenda tonight? All right, seeing none, back to our agenda. Up first for continuations, we have the application of 61-20, Echo Land Development LLC, 0 Percival Road, Lot 4 and T-Ticket, requesting a comprehensive permit to construct 16 single-family dwellings. 4 dwellings will be affordable. Voting members on this project are myself, Bob Dugan, Scott Zelinski, and James Morse.
Point of order. And maybe Bob could straighten it out. You were elected to town meeting member?
Yeah, so I was elected to Finance Committee.
Yes, that's what I meant.
Yep, and through Finance Committee, because they don't meet through September, the town's given me a opportunity to defer my actual position, so I won't be sworn into Finance Committee until prior to September.
Okay, the swearing in.
Yeah, so that settles it.
All right, so
And I got information from Town Council and Derek Vieira.
all right, so that takes care of that. And Bob, for this file, do we have anything new in the file?
Yeah, so we have 2 things that were new. David Wall submitted, not David Wall, I'm thinking of a builder. Brian Wall submitted a proposed findings information packet, and then we have a letter dated 4/7/21, and this is from Corrine Swain. It says, "My name is Corrine Swain. I live at 149 Percival Road, which is directly across the street from the proposed project. I'm strongly opposed to this project because of several concerns. My first concern is the additional traffic this is going to create on Percival Road. I hope that everyone voting on this project has driven down Percival Road to fully understand this concern. This is a one-lane road. Cars traveling this road must pull over to let oncoming cars pass. The additional traffic will be a burden to the residents living on the road. How does the builder plan to prevent the residents of his project from using Percival Road? My second concern is the exit of Percival Road onto Trotting Park. This has been a major concern during every meeting. There is difficulty seeing oncoming traffic when exiting Percival Road onto Trotting Park. Please also keep in mind that there is a bus stop there. Again, the additional traffic will only create more of a hazard. My final concern is the overall appearance of the project. I do not see much of a landscape plan. The builder plans to keep a natural border between Percival Road and his proposed project. This natural border he is referring to consists of brush and dead pine trees. If this project does pass, I would request that the builder provide a better barrier consisting of Leland cypress to maintain a level of privacy for the residents of Percival Road. And I do know that Mr. Montero did update a waivers list. The file's just so big. But he did send an updated waivers.
All right, anything else?
That's it.
All right. Mr. Montero?
Hello, Edwin Montero, I'm the applicant. Plans that were submitted, I don't know if anybody has any questions for me or questions for the peer engineer.
Presenting any new material tonight, Mr. Montero? Or you
Would
just
you
want to
requ-
turn it to board questions?
What you requested last time, the plans haven't changed. It's the same thing from the last hearing. The only thing that we've added was we hired the land surveyor to do the survey on the property, and he has stamped the plans, and it's the same thing as the original plans that we submitted back when we first filed the application.
Very good. Did you obtain a memo from the building commissioner?
I'm sorry?
Did you obtain a memo from the building commissioner?
I'll leave that to my lawyer.
Did you do a new survey for site distance?
Yeah, everything is on there. The surveyor is not doing the site distance. The site distance is done by the engineer, which was approved by your peer engineer. So the land surveyor doesn't do the site review. He's doing the perimeter of the property.
You're right, I haven't seen the peer review approval of the site distance. I mean, there's a question with the height of the fence.
Yeah, the fence that's there, we also sent another memo. The fence that's there is a chain link fence, but we sent a memo, I believe, over to Noreen. Basically, if a fence is being put up on someone's property, and it does obstruct coming out to a road perpendicular to the road that you're coming onto, you cannot put it up to obstruct anybody's view. It's part of your bylaws. We did submit it over to Noreen. I'm not sure if you've seen it.
So what you're saying is the property owner could not erect a 6-foot fence on their property because it would impact site distance for a proposed plan you're building.
If that's just in general for any street. You can't obstruct somebody's view when you're coming out perpendicular to a road.
All right, I'll defer it later, we get into it. I'm not a voter, but I'm still confused as to that. I know what you're saying. Thank you.
All right. Guess we'll go down the line here with board questions then. James, anything?
No, thank you.
Scott?
I guess it's for your legal representative. You're gonna defer that question to him. I'm gonna ask the same question that, the chairman has asked about. Any written documentation with respect to buildability? Or are you standing on a conversation that you had previously?
I did receive an email, and I forwarded it to the board. I thought it would be read into the record tonight, but I'm happy to read it. If you recall, at prior meetings, I made representations to you that I had conversations with Mr. Gore. And Mr. Gore is no longer, in his position, so I met with Mr. Street. But this was all new to Mr. Street, and I asked him to speak with Mr. Gore and see if we could all get on the same page. What I ultimately received was an email from Jonathan Dickinson, Assistant Zoning Compliance Agent, and it was basically an email that he had forwarded on to me from Town Council, Mr. Duffy, and I'm happy to submit it into the record, but if I could read it, I'd be happy to. Mr. Dickinson says that Mr. Street asked me to send you this from Town Council. There's a plan of land showing Lot 4, Percival Road, recorded in Book 586, page 39, which was endorsed A&R by the Planning Board in 2000. Lot 4 is shown on the plan with 5.46 acres and is encumbered by a note, not a building lot. And if you recall, that's been the whole concern here. Why is that note on there, and what can we do about it? The plan itself does not reveal a reason for the endorsement. Mr. Lebhurst's letter of December 2nd mentions the note is on the plan because there was not a clear determinant of access to Lot 4 at the time the plan was approved. This statement comports with other information presented to the ZBA by neighbors that Percival Road is a private way and Lot 4 does not have deeded rights to use it for any purpose. For purposes of this memorandum, I assume the note relates to the absence of a legal right to use Percival Road as access. The plan it may be endorsed A&R upon a finding that it does not show a subdivision, and every lot has frontage on a public way, or B, a way shown on a plan approved under the subdivision control law. Clauses A and B are not satisfied. And Mr. Duffy goes on to say, the applicant may submit a new plan for A&R endorsement without the note on Lot 4 if circumstances have changed and if there is a determined right to use Percival Road for access to Lot 4. I don't know why he continues to harp on Percival Road, because my letter
Just
came
do me a
from...
favor, just read it in its entirety.
The ZBA, acting instead of the planning board, may grant an A&R endorsement without the note, but it may not do so unless and until the right to use the way is clearly established. A right to use the way is required by state law and is an essential element of the endorsement, may not be waived. The applicant may submit a new plan for approval under the subdivision control law, and the ZBA, acting in its stead, may consider and approve it if it meets all requirements of the law and the planning board's rules and regulations. In his letter, Mr. Lebhurst refers to a new plan with access to the parcel from Trotting Park Road. This new plan is a subdivision plan, and the ZBA must treat it as such and process it in the normal course of business in accordance with the subdivision control law and the planning board rules and regulations. While the ZBA has the same power to issue permits or approvals as the planning board and may grant waivers of the local subdivision rules and regulations, it may not waive or grant relief from the requirements of state law with respect to the subdivision control law. The purpose of the subdivision control law is protecting the safety, convenience, welfare of the inhabitants of the town. May I submit the letter into the record?
Yeah,
Of course.
I would say this, I think the letter more or less is what I've been saying all along. If Mr. Gore initially said, and I think that letter basically says the same thing, that endorsement was there because there was no determination of access. Mr. Duffy is clearly saying if you can show access, then this board can essentially waive that notation. He talks about going to the planning board for a new subdivision plan, but he also talks about this board under 40B acting instead of the planning board. So what I'm ultimately saying to you is you have a 40B in front of you, and Mr. Montero, I think, has pretty skillfully presented it to you, but that note can be waived as long as you have a determination that there's access to the parcel. And I think Mr. Montero has submitted a plan showing it. You wanted a land surveyor to stamp it, because last time apparently that was an issue. He had subsequently gone out, and now the land surveyor has stamped it. The lot lines are depicted on the plan, I think, pretty carefully. So I just don't see the issue with respect to that notation any longer.
Can you direct me to the part of that correspondence that directly reflects the buildability of the lot? One statement, just one line that says it's a buildable lot in my opinion.
It doesn't specifically say that, but what it does say is, or if you read between the lines, is
I'm trying,
the notation.
forgive me for sounding facetious, but I'm trying to get away from basically, and I'm trying to get a definitive opinion from the building commissioner or one of, that's all I'm looking for. Counselor, that's it?
I have met with Mr. Gore. I have met with Mr. Street. There are letters from town council in the file. Mr. Duffy is clearly saying if you determine that there's access, then it's a buildable lot, is what he is saying.
Okay, thank you. Thank you, Mr. Chairman.
I have a follow-up over on that, but
Go ahead,
I,
Joe.
did you say yes?
Yeah, go ahead.
I think the letter also said you could simply remove the note and then there wouldn't be a question. And I didn't know this. You said, we cannot waive a subdivision law, which, I'll leave to Noreen or someone else. But to the best of my knowledge, the A&R note still stands, and there's been no requests to modify that A&R, to remove the specific paragraph at issue. And you can't waive, and we can't waive that.
What he is saying in the letter is, yes, the applicant could go to the planning board and submit an A&R plan. But he's also saying in the letter that pursuant to this hearing, this board is essentially acting instead of the planning board
Correct.
under 40B, and certainly can waive it.
But
It can
but
waive
you
many-
did
it
not.
can waive many things.
You did not request that per se. I mean, you said we could, but you have to, I'll move on. All I'm saying is, we did not get a specific request to alter that A&R as far as the note.
Well, you can consider it requested right now, and I'll have Mr. Montero amend his request if that really is an issue. But of course, we're asking that a notation that it not be built upon be waived, because we're seeking to build on it. So yes. And I think the board, I think Mr. Duffy's very clear in his memorandum that this board has the authority to do that.
No.
It's a comprehensive permit under 40B, and I think it's very clear that the board can, if this board determines that there's access from Trotting Park Road, this board can waive that notation.
I would, and you probably know better than that, I would look at what you need to do to modify the A&R under the subdivision rules. Whether, it might be a simple note, I don't know. When I read it, because it looked like you might have to go back in front of,
Well, I suppose it could be added to the request for waivers for Mr. Montero, but again, he's here under 40B for a comprehensive permit, and I'm quite sure, if you read Mr. Duffy's letter, he's not suggesting you have to go back to the planning board. He's saying this board has the very same authority as the planning board in this matter.
okay, I think.
Bob, anything?
One more question on this, Mr. Leprous, just because I'm just reading this over, so I didn't look at it earlier. So it looks like there's two choices here. Either Mr. Montero could submit a new plan and ask for us to take the note off, filling in for the planning board, or we would then have to look at the current plan for approval under the subdivision control laws. Is that correct? It doesn't seem like there's something that says waives. It says either they could submit an A&R for endorsement, saying there's new circumstances, and we could approve it instead of the planning board, or we could get a plan, we would have to look at the plan under the subdivision control law as filling in for the planning board, which looks like a second option. Is there an actual waiver option? Because it didn't look like there was a waiver option.
I don't know whether Mr. Montero put that specific request in, but he can certainly amend it.
No, I was just reading what this says, that's all.
What you gotta realize is, you're talking about an A&R lot, is, for example, is if I was going before the planning board and subdividing it into two lots. I am not doing that, I'm filing a comprehensive permit. So we're talking two different type of apples and oranges here. I filed a comprehensive permit on for the 40B. I am not going for an approval not required.
Your lawyer just referenced that.
That's what was on the original plan. An A&R approval not required would be if I was going before the planning board.
He just read an email, Mr. Montero, that town council that he used as an argument.
He's using it as an argument as if I was going before the planning board.
Well, it coincides with what Mr. Dugan's reading.
From what I'm getting out of this, and Mr. Leverett can correct me, from what I'm getting out of this is at one point, there were two lots. There was an A&R plan put in on one of the lots. They put a notation on it, not a building lot. That was was that
I think
second
there was
section.
actually more than 2 lots, but yeah.
Okay, whatever it was, there's a half section that was not a building lot. In 40Bs, we fill the job of the planning board. So anything that you would normally go in front of the planning board, you go in front of us because we're in their stead. This letter seems to state that the choices are, you can submit a plan for an A&R endorsement through the ZBA acting as the planning board, which could grant the endorsement without the note. If there was a right to use the way is clearly established, or the applicant may submit a new plan for approval under the subdivision control law of the ZBA acting instead of the planning board, and may consider and approve it if it meets all requirements and laws of the planning board's rules and regulations regarding subdivision control law. I'm just trying to understand, I don't see anything else in here about it looks like we would have to get 2 different things to happen.
There's a note on a plan, and ordinarily, if we weren't in a 40B comprehensive permit hearing, we would go to the planning board and ask to have that note removed. We'd file a plan, and we would show that there's access from Trotting Park Road, and we'd ask to have it removed. Mr. Duffy is clearly saying this board can act in the place of the planning board for that very same purpose. If the board is going to require a new plan, I don't think that's a problem at all.
No, that's not what I'm saying. It says that the board could act in that purpose of the planning board, but said to do that, we must have a plan submitted to ask for the change in the A&R endorsement from the ZBA.
Well, you've got a plan. I mean, you've got a plan of the very same property and a 40B. And he's clearly asking to build. He could ask, in my opinion, as one of his waivers, to have that note essentially nullified by the board. I mean, the whole point of the inquiry was, is that note gonna hold up building? And it's very clear in Mr. Duffy's letter that no, it doesn't last in perpetuity if you can show that there is access to the property. So Mr. Montero can certainly ask as an
I just didn't know
additional
if he was making a request to get the note
I
removed.
don't read that
or-
letter as having to fully come in and apply for an A&R plan to this board. I think he's saying, I think he's analogizing what this board can do to what would happen if we were before the planning board.
So so there's just 2 paragraphs, and that's why I keep sticking. So he says the applicant may submit a new plan for A&R endorsement without the note on Lot 4 if circumstances have changed and there is a determined right to use Percival Road to access to Lot 4. The ZBA acting in the stead of the planning board may grant an A&R endorsement without the note, but it may not do so unless and until the right to use the way is clearly established. The right to use the way is required by state law and is an essential element of the endorsement and may not be waived. Then he says, the applicant may submit a plan for approval under the subdivision control law, and the ZBA acting instead of the planning board may consider and approve if it meets all requirements of the law and the planning board's rules and regulations. So, I'm just saying, according to what this letter is, it looks like he's only giving us 2 choices. It doesn't look like, he says either something submitted and we deal with the A&R plan, or we don't deal with the A&R plan and we have to look at everything under the subdivision control law.
He spends a great deal talking about Percival Road. Now, Mr. Duffy wasn't present at any of the prior hearings to my knowledge. He does, towards the bottom of that email, he does talk in terms of Trotting Park Road. It's clear to me, and I think it's very clear in that letter, that the notation can be waived. It can be waived by the planning board, or according to that letter, it can be waived by the ZBA standing in the place of the planning board. Now, whether or not this board's gonna require a new plan to accompany the 40B application, you have the property on a plan before you. Granted, it's not an A&R filing, but it's not gonna be an A&R filing even coming out of this board. We're not gonna record a new subdivision plan at the Registry of Deeds. This is a use issue, and I think he's clearly saying that this board under 40B can waive that notation. And I think if we make it, I think if we add it to Mr. Montero's list of waivers, I think the whole issue goes away.
Okay, the only other 2 questions I have, and they have to do with the development itself. Can you just give me a little background or explanation of what exactly exclusive use the exclusive use boundaries are and what they could affect. The
I
exclusive
think
use
that's a question
areas.
for Mr. Montero, but, yeah.
On the exclusive use area?
Yeah, just wondering, and I know you did on the, almost to the lot borders, that each individual property has an exclusive use area.
Correct.
And I'm not really that familiar with exclusive use areas. I've only run into them once, and it was very limited, so,
You see it a lot in condominiums.
Yeah.
Because you're not dividing land, you're sharing land, and, a unit will have a certain area perhaps outside of the physical building that they have use of. They don't have the fee to it, because the condominium association does, but the agreement would be that that's their exclusive area of use. It's sort of like a lot line in condominium law. And that's why this is a condominium project, and that's why you see exclusive use area. It's a condominium way of having a yard, essentially.
so they could basically use the space, but they can't do changes like take trees down or, if we have like, let's say there was a buffer zone or something in
I
there.
think if they don't own it, so anything that they were to do, and it would have to be done with the approval of the condominium association.
And as far as this,
But if they're under permit from your board, obviously, I think any change to the site would require some kind of a visit back to the board.
and as far as the septic systems, I know they're all individual, so the individual unit owners would be responsible for,
Correct. They would be responsible for maintaining their own units, their own Title V.
and my only other question was regarding winters. What do they do as far as snow removal? Is there any,
I sent,
move it from site or?
I sent you the HOA information. They'd have private snow removal.
So they would just remove the snow from the site? Is there an area to push the snow to or anything, or?
Well, basically, if you look at the plan, I mean, the snow would probably be going to the left-hand side of the private road or down towards the end, as you would do on any street.
Okay, that's the only
So
question.
each individual homeowner is responsible for their snow.
You have an association where you would be hiring someone, but someone would coming in plow, just like they
They
would.
pay into their condo.
That is correct, and they also would have their own private rubbish pickup, which would be the same type of situation.
Anything else, Bob?
No, I think that's, and there's no issues with putting snow or anything to the side of the road, right, with the catch basins or? Or well, I guess they couldn't go to the very end anyways. So I guess they would be limited then just to that left-hand side of the road, correct? Because they couldn't go to the end because they would then have issues with the turnaround and the.
The turnaround is before the end of the road. The T. If you look at where the last two houses are, that's where that
Yeah,
is.
right at the corner. Okay, that's all I have.
Scott, anything?
No questions.
Could I ask the peer engineer? Or,
I had one question.
Oh,
for
sorry.
Mr. Mont-
Go ahead.
No, it's okay. Mr. Montero, so I know as proposed, this is now condominiums. Regarding the individual septics, who would be responsible for maintenance and replacement of those?
The individual homeowner.
Okay. That's the first time I've ever seen that proposed with a condo, so that's why I
Well,
wanted to
with the exclusive use areas, you're doing them in phases, 4 units at a time. That's why we can go with the Title V septic systems.
Did you give any consideration to, I guess for lack of a better term,
Yeah.
community-wide septic?
Yeah, we looked at them. I've installed quite a few of them in different projects. And what you don't realize is even one project we completed for somebody else, when you have the system that's all done with sewerage going into one holding tank, going into a leaching field, one project that we were doing, we would always tell the homeowners when they were flushing, just make sure you use things that they can apply to the sewer. And if someone in that system throws a foreign object in there, it clogs it up, and it also holds up the whole system from pumping it into the chambers and everything else. So you basically, everybody has to be on their best efforts not to be putting any type of foreign objects in the type of community type of sewer system. With the individual ones, you're gonna have more of a purpose of not doing that, because you know you're gonna have to be taking care of it and pumping it every 2 years to make sure your system is running correctly.
All right. Any other questions for Mr. Montiero?
Yeah, so on the septic again, so let's say there's a failure to one of the systems, let's say an affordable unit or someone doesn't take care of it and the system fails. And they don't immediately upgrade it, or they don't have the monies to upgrade it. How does the association handle it? Are they doing a separate fund for that, or?
Well, something like that you could do. In the past, I've worked with the town of Barnstable. They usually have the programs you can do for your sewer systems. If somebody can't afford it, they do a replacement of the sewer system, and they give you a loan type of loan for to put a new septic system in.
So where this is a condominium complex, if something like that happened, is the complex then in,
The individual homeowner chooses not to do that or doesn't take that avenue.
Well,
What protects you
I
from
mean,
that?
is the
Mr.
complex
Well,
in
the bo-
violation then? Because they,
No.
when they do the condominium inspections, they do it for the actual condominium and then,
That is correct. There's a common system, but if you have a violation of your septic system, your Board of Health would be coming in. So for example, if a leaching field failed or a septic system was overflowing because they didn't pump it, it's not up to the association. Your Board of Health, your health agent would come in there, and like anybody else in town, whether it's a single-family home, condominium, they would have to come in and enforce them
Your
to.
condo docs are splitting up municipal applications. Some are on their own, some are,
No,
some are with condo docs, right?
it's an individual system on that exclusive use area.
I'm sorry, maybe I didn't. You're talking about the condo association paying for the snow removal,
Correct.
but the homeowners are responsible for their own individual septic systems.
Correct.
All right, so if they choose not to, they're gonna be under direct violation and it doesn't cross over into condominium rules? Is that what you're saying?
That would have to be how it's been written up, but the point is, again, when you're in violation, it'd be no difference if somebody is putting up a clothesline or they're doing something illegal. Your board, whether it's your zoning commissioner or your Board of Health, are the ones that have to enforce it. Just
And this
because,
is all conceptually, this isn't in this filing, right? How that's gonna work?
your master deed and your condominium deeds, no, that has to be, whatever you have approved, that's what we put in.
I'm not trying to be argumentative. I'm trying to get
I'm not-
to the bottom line of who's gonna do what after the fact. And if it's not in
It's,
this
it's,
application,
it's
we're
the.
just assuming things.
No, you're not assuming. Again, George, it's the individual homeowner on its exclusive use of the use of the property that we have.
And that's written in this application where?
There was no type of system before we were doing the development. Okay, so whether it's in the application, you have it in the proposal on these plans for what we plan on doing on that. And it will be incorporated in the condominium documents.
So the condominium documents, could it be,
Could you silence your cell phones, please?
I guess what was,
so they could submit their
oh, wait a
HOA
minute, Bob,
plans
Bob,
after.
Bob,
Yeah.
Bob, please.
I think what we may be suggesting is that condominium documents have a clear right to enforce against a homeowner that may be causing a public health. Although, you're right, it is the Board of Health. A lot, and I'm not involved with condominium, I think condominium documents could be an overarching reviewer to make sure people safely maintain their property in case they don't do it.
I mean, that can be added, but again, you
Because
have to.
the homeowners don't own the land.
They have-
Condominium owns the land.
Correct.
So the septic systems are on the land that the condominium owns. The exclusive use agreement just allows actual use,
Of the property and to maintain that property.
but just use. So and that's why I'm questioning it. So if something goes wrong with the system itself doesn't have anything to do with the exclusive use. The system has to do with the way you wrote your condominium dockets, that they're gonna be responsible for the system that's on condominium land. But if you have a system that's in failure, and this is what I'm asking, and nobody upgrades it or does it, which happens once in a while, maybe it'll never happen, but it does, because it's one parcel for the condominium itself, I would assume, would be under enforcement, the complex.
Well, that could be added, and it could also be added as another HOA type of fee.
I don't know how else, I just don't know how else you would do it, since they don't own the land, they don't own the lots. I don't know how else that you.
Well, it's the
would do it.
percentage of everybody owns it, but again, with the exclusive use area, if it has to be enforced by the condominium association, that can be added to it. But again, when something fails, you have your different departments that have to enforce the laws.
Have you ever dealt with, just, you may know just from your experience in real estate or developing, have you ever seen a condominium a setup like this on a condominium? Where it's basically a unit where you handle your own septic system, there's an exclusive use area just for use of the, enjoyment of the land, but the association still is responsible if there's an issue?
You have that over on Mill Way, off of Old Barnstable Road.
Great, thanks.
Bob, I've had a little experience with this sort of issue where there's multiple septic systems on a 4-unit condominium. The documents clearly state one particular unit is responsible for the upkeep of a particular septic system. In the event of a failure, the specific unit owner would be responsible for updating or fixing the system, and if they fail to do so, the condominium association would step in.
Would step in.
Make a
So it'd be
special
an
assessment
that's what I'm
against the
looking for.
unit, fix the issue, and then enforce the lien that they would have pursuant to the condominium law.
Okay. Thanks, James. All right, anything else for Mr.
But
Montero?
it gets back to documents, it has to be
Yeah.
very clearly
Docs.
delineated.
I had a question for the peer engineer.
All right, so, anything else for Mr. Montero? Because we'll
Oh,
turn it over to
it
Paul.
relates to, oh, not Mr. it relates to site distance, which,
Right,
can
well,
leave.
I was gonna
I'm sorry.
allow the peer engineer to get up
Okay.
if we're all set with Mr. Montero at the moment. All right.
Adal Shaheen, peer review engineer. So, as Mr. Montero said, they submitted revised plans last week, end of last week. And this week, I think we received also a list of waivers. Three of them for the zoning waivers and the 23 of them for the subdivision waivers. So, in regards to the plans, as you said, there's nothing changed. They just have the stamp of the PLS now and the PE. And, but we noticed they're a little bit clearer than last time, so they're more legible. You can see them a little bit better. There's also separate plans now for drainage and utilities, which is also helpful for the, to build them. So, but those are the only changes that happened to the plans since we last met. Regard to the waivers, we looked at the subdivision waivers, and in particular, we looked at the ones that pertain to safety for the public or the users. There's 23 of them. I can go through the ones that I've really had reviewed and commented on, and the rest of them are really just not really related to safety, just not meeting your subdivision laws. The first one of them is related to the length of the driveway, not to exceed 500 feet. It's my understanding that he already had asked for letters from the fire and from the police department regarding that issue, that does not meet the 500 feet length. So if he hasn't done so, we'll probably need to get a letter from them, from the fire and from the police, that they're okay with that not being, exceeding the 500 feet. The second one, I think we already have a letter from the fire department, which is number 2, which is called about the turnaround area. He has provided an area 20 by 60. I think the fire department has accepted that. Next one is number 7, relates to the roadway center line, should be a minimum of 150 feet. The plan shows the correction, and also it meets the design speed of 20 miles per hour for residential roadway or driveway. So that's acceptable. There's also waiver for vertical side distance, that's request number 8. Again, the design speed of 20, it meets that vertical side distance. That's along the driveway itself, so that's, again, there's no concern, no safety concerns. Waiver number 10, it talks about the slope of the grade at the intersection. I think it's slightly increased, it's supposed to be maximum of 2%. The plan shows 2.14. That's not really a significant, increase, and it doesn't show any safety issues. Number 11, again, it has to do with intersection with the with the Percival Road and Trotting Park Road. If this remains as one single intersection, then this is not an issue. Again, the only issue is the side distance. We brought that up last time about the side distance. The plan shows the side distance, but it shows for 3 trees to be removed. And we don't want to have any obstructions, because if there are any obstructions along that side, that could be a hazard issue. People have to pull out a little bit for driving to be able to see on your right side and your left side, and that could be
Who owns
intruding.
the 3 trees?
The 3 trees are shown in the plans. I think the public right, within the public right of way, I believe. Let me go to the plan. Yeah, they're within the, 2 of them within the public right of way, and one of them, I don't know if that line, the third one could be in the private property.
Say again?
The third one may be on the private property. That's what, according to the plan here.
Thank you.
Yep. And I believe that's it. That's it for the list of waivers that we reviewed as related to the safety. The rest of them, as I said, they're just not meeting your subdivision bylaws.
All right, thank you. So we'll turn it over to board questions for our peer engineer. Jerry, did you have anything?
Yeah, and it might be more of a legal issue. I think from an engineering perspective, if the property owner said they were gonna put up, I think it was a 6-foot, or I think they might have said a hypothetical, a 6-foot high fence that clearly interferes, that 6-foot fence now, that wouldn't interfere with anything. Could they do it, as far as you know? In the past, you said they're usually set back, and I guess this is more of a legal issue. Can a private property owner put up a 6-foot fence on their property for privacy? Or does state law prevent them if they interfere with sight distance?
Yeah, I said near intersections, I think there may be some rules. I don't know really if there's anything in the town of Falmouth that speaks to this. I know other towns have setback requirements near intersections. You cannot have it more than 10 feet.
Yeah, I know, Mr. Montero said there might be a state law that
Right.
prevents it.
Yeah.
I just didn't know from your engineering perspective.
Town law.
Yeah.
And I sent it to the board.
I might have missed it.
Anything else, Jerry?
No, thank you.
All right, James, anything for our peer engineer?
Not for the peer engineer, thank you.
Scott?
Nope.
Bob?
No.
Scott Peterson?
Nothing?
All right, thank you.
All right, thank you.
All right, does the board have any follow-up questions for anyone? We can turn it over
I
to...
have a question for Mr. Montero, if that's all right.
Sure, go ahead.
I did read one of the comments from the fire department regarding the driveway, that the fire department found that the T turnaround would be acceptable as long as it was not gonna be blocked. What's the plan to keep that open?
On the plan, we would have signs up there stating that there is no parking, whatever the fire department would request on that. It has to be removed from any parking or any type of kids playing down on that turnaround.
Thank you.
But there would be signs posted.
All right, anyone else?
I have a question, but it's actually for the administrator. So, Mr. Montero said he had sent over that thing, and I'm sure he did. Do we have a copy of that in here, about the town regulation about blocking sight distance with fences? Only because I just don't remember reviewing it, and I'm sure he sent it over. I don't know where it would be in here.
I'm not sure, but I can certainly get a copy of that.
Okay, thanks.
All right, so we'll turn it over to...
Yeah, if you have it, that'd be... Yeah, it's just, I don't know.
Could you read it, or is it a plan?
Oh, this is the brochure they talk about when I'm putting up fences?
Oh, I remember that brochure. So that's the yellow brochure. Fences,
Fences and sheds, yeah.
yeah, okay. I'm gonna go
So what
back
it
and
says here,
reread it.
basically, it says fences, it says Town of Falmouth Building Commissioner, Zoning Enforcement Officer is the Inspectional Services Department, will answer questions about zoning and building codes. And Conservation and Historic District owner shall confirm whether or not their property falls within a historic or conservation area prior to erecting a fence. If this is the case, the application shall be filed with that department. To ensure proper placement of the fence, owners shall have their property surveyed by a certified land surveyor before fence installation. On zoning issues, with the exception of property within a historic district, there are no zoning regulations regarding the style of fence property may install or which side of the fence should face abutters. According to the town bylaws, fences are allowed to be located on the property line. However, it is highly recommended that enough space is left between the fence and the property line for maintenance without the need of trespass on an abutting property. Fences shall not obstruct pedestrian or vehicular visibility on a public way. Fences shall be lowered to prevent blocking the line of sight at the end of a driveway, sidewalk, or public way. And then it talks about the height regulations, anything greater than 7 feet needs a permit. Thank you.
All right. So I think we'll turn it over to public comment at this point. If anyone out there has any questions, comments, or concerns, Attorney Wong?
Thank you, Mr. Chairman. If I just can have a second to put in this flash drive.
Go right ahead.
Do you know what the password is?
I think
do
it's
not.
password. It might be right
Seriously?
there.
Ashley might be able to help you.
It says it right at the
Yeah,
top.
it says it, okay.
Password one.
Okay, thank you. Good evening, members of the board. For the record, my name is Brian Wall. I'm an attorney in Sandwich, and you've heard me say this before. I represent 3 property owners on Percival Road. This project first began 16 months ago, and you've heard me say many things at the podium during that entire time. I'm not going to repeat the things that I said before, and I'll try to honor the time limit that I'm under. What I want to focus on tonight is essentially the road. But before I get there, let me just say this. So 40B, we all know what it is. It's a balancing test. It allows a developer to come before you and ask for waivers to override local zoning and subdivision regulations in the interest of promoting affordable housing. In order to do that, the developer has to provide you a very specific list of waivers so that you know what you're being asked to waive. And that list is really important for another reason, because it defines what the board then has to do. And the board has to engage in a balancing test. Do you grant the waiver, and what do you balance that against? You balance that against local needs and local concerns. And local concerns is defined in the 40B regulations. I'll read in part. It includes the need to protect the health and safety of the occupants of a proposed project and the residents of the municipality, and to protect the environment. So you're being asked to engage in a balancing test, and the developer has to make a case for each waiver, each single waiver that they're requesting, balance that against those local needs. And we have been asking from the get-go that the developer provide that list of waivers. And last August, so we've come a long way, the list was 5, and now we're up to 23. And I would suggest to the board that the 23 waivers now have really brought this project into much more focus, in my humble opinion, than it's been before. And so I'd like to just highlight 2 areas where we think the board should focus its review. The first is with groundwater and pollution. The project is in a coastal pond overlay district and a water resource protection district. The regulations for those particular districts require a subdivision of this size to have a common septic treatment plant. And if the developer can show that that's not feasible, the fallback position is to have denitrifying septic systems. The proposal is for neither of those. It's for individual Title V conventional systems, and there's been no showing by the developer that he can't put in a plant or he can't put in a denitrifying septic system. And so we would respectfully submit that these particular provisions of your local concern should not be waived. And the second area that I want to talk to is about the road. The requests for waivers that have been submitted, I counted them. There are 13 requests for waivers that concern safety matters of the road. And I won't list them, they're all in the document that you've been handed. But insofar as the local concerns are at issue, the board needs to look at the occupants of the development and also the people of the municipality. And both are at issue in this particular case. Obviously, the 16 residents, the 16 homeowners that might live in this development are gonna be at issue. But in this particular case, as I've mentioned before, the developer is actually using this part of Percival Road right here, which is access not only for this particular parcel, but it's access for the people on Cardozo Road up here and on Percival Road out in this direction. And so insofar as the development is concerned, we would submit that there are numerous requests for waivers that present health and safety concerns. And I'll start back here, which is actually not on the plan. First of all, the road is 1,300 feet long, and it's a dead end, and your regulations say nothing more than 500. The second is the T parking position. There's supposed to be a cul-de-sac for turning around. They're asking for a waiver of that, and they're proposing a T parking situation, and the questions earlier were about how is that gonna remain clear? And the developer has said they're going to put up signs. But I would respectfully submit, with 16 families living here and no other parking available at all, it's simply not realistic that that's gonna be honored. There were also provisions required for, and this is coming from the engineers department, a bus stop for safety for children. There's private garbage pickup, and there's also supposed to be mailboxes, and there's been no provisions made for any of these types of services that are going to be occurring. But most important to my particular clients is this particular area that's shown on the plan, and I'd like to highlight a few things. This area right here is where I've focused most of my comments. The applicant, if you recall, when they first came before you, proposed use of Percival Road up here, and the idea was that there were gonna be individual driveways to that road, and also there'd be two means of access, two ways in and out of the subdivision. The developer did not have rights to that particular road. So what he did was he simply just said, okay, I'll put a road on my own property, and he put it right here. But this area here is so poorly designed, it's going to present hazards. Let me point out, this is where the stop sign is supposed to be, according to the plan. So if you can imagine, if you're driving out of the subdivision like this, and you stop here, you're supposed to be looking for cars coming from here. I don't have a scale, but this is a house length. It's almost a house length back from the subdivision. So how is one going to see if it's safe to go in or out of the subdivision when you can't even see? Also, coming in and out of this area, they've almost kind of forgotten that there are homeowners up here, and how is the traffic gonna integrate coming in and out here, and how is it gonna integrate coming in and out here? This area has been reviewed by the planning board, by the town engineer, and by the peer engineer, and they all have recommended against approving this particular configuration of roads. The site distances were talked about quite a bit. What I heard the town's document about fences, it sounds like you can put it on your property line, and it's recommended not to go near an intersection, but I didn't sense that as a rule. But most important of all, and I think this is a critical point for safety, this is the developer's plan that we've colored. These are the site triangles that are shown and that are necessary for safety. If I can point, this long triangle, here's the point of it right here. This is the road, Trotting Park Road right here, and this is the site triangle line. And there's one here and there's one here. According to the town's website, with the speed of this particular road, the distance is supposed to be close to 400 feet, but what's proposed is 150. But what's most important about what's being proposed is a site triangle is an area that is supposed to be under control of the developer and then subsequently control of the people that take over the subdivision. In this case, it would be the condominium. In order to keep it clear of visual obstructions so that one, when coming to this intersection, can look left or right and see. That's why it's called a site triangle. The developer does not own this property. So the developer is showing you a plan with site triangles that the developer has no ability to create or maintain. And so based upon all of what I've said, I would respectfully submit, and again, I highlight, the planning board has recommended no, the town engineer has expressed serious safety concerns, and the peer engineer has said this intersection and this intersection are unsafe. For all of those reasons, I would suggest that when you get to that balancing test of weighing local concerns and local needs versus the need for affordable housing, in this case, the balancing test should fall in favor of the people of the town that already live here, and I would recommend that you deny the project. I know I've probably gone over my 2 minutes, so thank you very much for allowing me to.
Thank you, Attorney Wall. Any questions for Attorney Wall? No? All right.
Thank you very
Thank
much.
you for your time. All right, anyone else out there have any questions, comments, or concerns regarding this project? Sir?
Oh, could you leave that up there? Could you leave that, that map up there for me? Appreciate it. Thanks for your patience. Thank you. I'm Robert Cole. I live at 197 Percival Road, and we recently moved to Falmouth. It's been a lifelong dream to live in this community, so we're happy to be here, and we learned about this project shortly after coming here when we found out that a previous iteration of this plan included some of our property, which they hadn't bothered to read the map and find out that we owned it or that we were part of it. And apparently, according to this as well, those triangle set lines go right through our property, right there. And apparently one of these trees that's supposed to come down also comes through our property, and nobody's talked to us or asked us anything. And it seems like there's a lot of stuff in this project. It's been going on for 2 years that hasn't really been well thought out. Apparently they haven't talked to me, they haven't talked to any of the neighbors about these concerns, or they really don't seem to care about our concerns. And they don't have their septic figured out, we know that. They don't have the traffic figured out. So I guess what I would posit is that this plan isn't a very good one. Putting 16 people into that property in this configuration at least doesn't seem to be very well thought out. And I'm not just here to oppose it because I oppose it. I'm opposing it because nobody asked us if they could use our land for this plan, and they're trying to, which means that what's going to happen when they start building? What's going to happen when they start putting construction trucks up and down this road? What's going to happen when there is a problem with the septic? Are their neighbors going to be consulted or talked to or communicated with? Are these people going to be, is this project going to be a wholesome part of our community? What recourse will we have after you say yes to this project, if you do indeed say yes? We're hoping you won't, but it seems like they don't have their ducks in a row. And once these things get started, things get even messier. And then once they're built, like, what are we to do? We have no recourse at that point. So I would just ask you guys to take an even more, a longer look at this, because I imagine if this wasn't a 40B, you guys would have kicked it out of here a year ago. But since it is, you're giving it more consideration. Maybe a smaller project. Like, maybe do it with 4 houses or 5 houses or 6, but like 16 doesn't fit. Yes, sir.
May I ask you a question?
Yep,
In all fairness to the applicant,
sure.
you'd still have the sightline issues, whether it was 6 houses or whatever that you're describing, right?
The traffic issue.
No, I'm talking about the plan in its preparation still encompasses your property, is that what you're saying? Whether it was 6 or 10 or 16 or whatever?
You know, I'm not the kind of person who's like, hey, I just moved here and nobody else can. And
No, I get it, I'm just
I don't
trying
think
to
that's fair.
clarify what,
Yeah, what I'm saying is, well, I mean, trying to make the sightline issue through our property, I guess the bigger question is, like, they didn't even know it was our property. Like, you have a developer here that didn't bother to go down to town hall and pull a map and find out who lived there. Like, does that strike you as someone who's gonna be responsible about how they deal with environmental regulations, septic, sewer, traffic, fire, the parking plan, et cetera, et cetera? I got a map. I know where I live. I know where every single person in that neighborhood lives. I've gone
Realize,
around.
though, we're not the ethics police.
I understand. I understand. Yeah, but we're looking for responsible development, correct?
No, I understand. That, what their intentions are after it is or isn't approved. We've found out that, you know, there's not a lot that can be done about it afterwards without enforcement, so.
And that's why you guys have the
Well
power
taken.
here today. Thank you. Thank you for your time, gentlemen.
Thank you. All right, anyone else? Ms. Harris?
Three quick, Pat Harris, 181 Percival Road. Three quick items. The point where the common driveway intersects with the existing Percival Road running in an easterly-westerly direction, there needs to be lines of sight on either side of that intersection as well. The developer didn't bother to develop it on their plan. But as you can see, the area in blue is land that is interfering with the ability to see what's coming along Percival Road on the northerly-southerly direction. Also, this prior correspondence by my attorney has been submitted to you saying that the traffic analysis books say that this development should be expected to generate 160 vehicle trips a day. Yes, the line of sight down at the intersection of Trotting Park Road and the end of Percival Road is bad right now, but when there's 160 additional vehicles as well as school children waiting for buses and trash barrels being brought down to the end, because we don't see any plans made for that. Oh, and lastly, if somebody were coming from Sandwich Road along Percival Road and took this left-hand turn down and wanted to get into the development, they'd have to take a 360-degree turn. That has been pointed out by our town engineer as extremely dangerous, and you can just imagine the traffic conflicts. As you walk, as you look where they widened onto their property, it's in orange. You go up a two-lane road and it stops at the blue section on that plan. Lots of confusion. Maybe people who live in the neighborhood are gonna figure out how to do it as safely as possible, crawling around the corners. But there's going to be deliveries, there's gonna be fire, there's gonna be police. This is a very unsafe design. Thank you.
Thank you. Anyone else? Sorry, I see a hand raised back there. I can't quite. Yep. Hi.
My name's Jessica Kowal. I live at 197. You heard from my husband, but as a mother of two young children, the number one thing that I heard from the developer was that there should be no children playing in the area of the turnaround ever. That's how they were going to plan to keep it clear, which is, I don't know, just very alarming to hear as a mom that has two children playing over here. But like everyone has pointed out, the turnaround as it is now, moving into this neighborhood, we've met most of our neighbors. Most of us are very kind and thoughtful of one another when we're entering the road that's clearly only one person. The deliveries that happen on our road personally are like a big deal. They have to go in and then back up. So you'd have a delivery truck backing up into a blind spot. Like how is that possible? I would say that this plan is definitely not thoughtful of the community around that's currently there. I know that we're new, that's obvious. So I'd just like the board to take that in consideration, that this would massively affect families that already live here. Thank you.
Thank you. Anyone else for public comment? Going once, going twice. All right, back to the board. Do you have any sort of follow-up questions, or Mr. Montero wants to address anything that was raised through public comment?
in regards to everybody talking about where the road comes in, if you look, this is my lot line right here. It actually comes down, and it's significantly, as we spoke before, Percival Road goes behind the Cape Verdean Club and is a dead end. This is actually Goat Alley. So there's a couple of issues that you have on that, because they're saying about traffic, fire trucks can't get down my road. If you've been down Percival Road, how do the fire trucks get down their road? At least I'm doing something where the trucks are gonna be wide enough where you can get in. What you don't realize is when he colored my site plan is, their whole road is coming onto my property, right there. And this is where I'm coming in, so I'm not encroaching on Percival Road. I'm on my own property coming on Trotting Park Road. The other situation is, okay, again, when I spoke at one of the prior hearings, they had a right-of-way on their own road when it was subdivided back in 1945. I told you there was 22.8 acres of land. What they had was an easement, 12-foot easement coming on their road, which would have been on their property, going on to Mill Way. The abutters that said they're at 197 Percival Road, their land actually comes on the side of where Mill Way should have been. Now, if they would have come with their own surveyor's land and shown the plans where they subdivided, that was the Pius property that was back there 50, 60 years ago, so I know the property. So when they say that I was cutting their trees down, I wasn't cutting their trees down, I wasn't even gonna attempt to do that. Where their property is to actually to the right or to the west of where Mill Way is. And if they would have come in with a regular surveyor showing where their pork chop lot comes on, they're supposed to be actually coming on the Trotting Park Road, not on the Percival Road, because they don't have that right on there, because that's basically an illegal address that they've given them, which is fine, they're using it now, but that's where their property was supposed to come if they would have come in with a survey on that.
Is that an assumption you're making?
No, it's not an assumption, that's.
Is it written anywhere?
Your plans are filed with the town. When I show you Mill Way has always been there since 1930.
So when they're describing the fact that they own that property, they're describing it in error?
What they needed, everybody comes in here and they say, I own this and I own that. If you come in with a plot plan, come in with a surveyor's stamp like you've asked me to do, show that you own that way. What I'm saying is, their land, this haphazard road that's going all along here, when it makes that left turn, it's coming onto my property. Now, they're talking about site review you can't see going down the way. You had a peer engineer that we worked with for 6 months. They made sure we had that line of sight. So you do have the line of sight for traffic and everything else where it's not gonna be dangerous. Now, whether or not somebody plants a tree or whatever, no one can control that, because if it's gonna block the view of the subdivision, it's gonna block their view too. Same thing with the fence.
So if they've been using whatever the location is, even the section that's on your land, after all these years, do you have any right to actually move the road off of your land, or do they actually have right to use that now because it's been used for so long?
I can let my attorney.
Used and maintained?
Isn't it
Well, I
right
mean,
of passage and
I have the right to use my own property.
No, I know you do. I'm just saying, if we're looking at the site distance at that other corner, and your argument is that, well, they're actually on my land anyway, so that's why it's creating more of a site distance issue. I don't think we can look at it that it doesn't exist. So if we're looking at it as a site distance issue, we have to look what's currently being used, or it's been used over the years and exists.
Yep.
If you're saying that the road could be relocated, we could look at site distance there in a different way. I'm just asking, is that a possibility?
No, I'm not saying that, because this road's gonna be widened coming in onto my property. So it's going to even be wider than what it is right now. And again, if that was gonna be an issue, when we were working with the peer engineers, they would have mentioned that was the problem, and it's not. I mean, so I'm coming in on my property where it's gonna be widened coming in over to here, but that will all be paved going in.
Can you, you're referring to the peer engineer.
Yeah.
He said that there were three, Mr. Wall had three concerns that he said that the peer engineer had also weighed in on, and one of them was was that intersection? Could you speak to that, please?
I would defer to him, because he's the one that did the traffic count, and if you recall back on one of the hearings, because they're saying that there's 90 cars or whatever, but on the hearing that was on December 16th, he says, we also looked at the trip generation. The peak hours in the morning is about 14 trips from 7 a.m. to 9 a.m., and 7 a.m. to 9 p.m., the peak will be 18. There's not a lot of concern for volume. And that's what they did, their own study. We didn't ask them, they did their own study on that.
You would agree that there's a pretty disparaging difference in their calculations and the opposition's calculations?
Well, the oppositions, did they come with an engineer? I mean, he was coming on his own layman's terms. We've worked with my engineer, and you have a peer engineer, versus someone that's coming with layman's terms.
Number of cars, is that layman's term or trip generation?
That's just the language that they use for it. I'm talking about, you have a lawyer talking about site view and site angles and triangles, where that's where the engineers come in. And I'm saying, if you have a lawyer doing the engineer's job, I would like the peer engineer to explain what we had to do to get your site view.
If you'd like to speak to that?
Yeah, but the plan doesn't show the plans. Keep going to sheet 9.
Yep, yep.
Again, this is the driveway here. We look at the side distance, somebody's sitting here trying to take a left turn. This is the triangle that they need to take, and this is calculated based on the speed and, and profile of the road. So this is not just any distance, it's basically based on design speed. So this is the distance that they showed, and we agree with that distance. Originally it was shown a little bit off, was shown here, but we asked them to move it and fix it, and this is what it's showing. And those are the trees I was talking about. Those 3 trees right here. I'm not sure if this is the property line here in the back of the tree, or the property line is the one in the front of the tree. I can't really tell from this plan. But these are the three trees that have to go. Okay, and then coming out, turning to the right, you see also they did the side distance. This is the line right here. And I don't think we need to move any trees for this one.
2 of those trees are in the public way,
2 of those trees are public
and
way.
1 is on private property.
Yes, I think it's this one here.
So either way, those 3 trees would have to go, and they're not on property that is
Yeah.
part of the
It's
development.
controlled by the applicant?
They'll have to remove them.
So what's what about the site distance at the top that they were discussing?
This one here?
No, up where you're coming out of the development and it first touches, not where it touches Trotting Park, where it connects higher up, closer to Percival.
Okay. And here, this one here? Yeah, I mean, there's a stop sign here. We commented on the previous design, where this was split up to 2
Yeah.
different access roads. But with this design here, I mean, we have a stop sign here, so people coming here, they can stop up to here. They don't have to stay away back here. They can go to the stop line. Here, there's no, why would you stop here? You can stop right there before this intersection. Then take your turn. So I don't think there's any.
May I?
No, go ahead.
What is your opinion on Mr. Wall's denitrification opinion?
I mean, if it's possible to do it, that's really recommended, again,
Pardon me?
is it required by the town? That's what I think. If it's not required, why would you do it? If it's required, I say, yes, we should do it.
So his argument has no merit, in your opinion?
Yeah, if there's no requirement, that's by the board, or by the subdivision rules, why would you do it? It's an enhancement, but not required.
Even with the coastal overlay and all the terms that were discussed?
Yeah, I think we did other projects like this before. It was accepted, so.
That's just for the record.
Yep.
Thank you, Mr. Chairman.
Anything else for our peer engineer?
Want to go back,
I-
so have you approached the town to say, will you take these trees down?
No, because the project hasn't been approved. I mean, once it's been approved, I would ask them.
And if they say no?
It's a moot point. I'm sorry?
If they say no?
If they say no, what can you do?
Okay, so, okay, you haven't had an approach yet that the town's willing to do it. It's their property, they may not, for whatever reason.
Okay, anything else from the board?
Mr. Chairman, could I be recognized just to clarify in point of information to correct the record?
Only to that one brief point, because we have closed public hearing. Not public hearing, public comment, my apologies.
Did I borrow here?
No.
All right.
Oh, come on.
I just want to clarify the record on 3 points. First, regarding what the peer engineer just said, denitrifying septic systems in a sewer treatment plant are required. Section 24099A of your zoning regulations for coastal pond overlay districts provide that they're required. Sorry, 100A, not 99, 240 100A. Secondly, I concede, I'm not an engineer. Let me clarify my comments about the site distances. Well, my point is, and I am a lawyer, so I'm qualified to talk about ownership. A site triangle is supposed to be under the control of the developer to keep it clear from growth and obstruction. The plan is showing site distances which the developer does not own. So he has no ability to control this area. He can't assure the board this is gonna stay clear. And lastly, I don't have the best plan, and Mr. Montero wouldn't share his, but the A&R plan that was of such discussion earlier about the not a buildable lot, that shows what Mr. Montero's property is, and his property line is in the middle of Percival Road. And so what that means is that he owns to the road, like he said, but owns to the middle. We have this thing called the derelict fee statute, a fancy term, that says that when you own on a way, you own to the middle, and the person on the other side also owns to the middle. But it is subject to the rights of all the people on that way to use that road. And so when Mr. Montero was saying things like, that's my road and they're on my road, he's correct, he owns the dirt, but he can't take the road off his property. It serves Cardoza Road and Percival Road. And so it's very important to understand, he is using a road to provide access to his development, that he owns half of the dirt, but it's subject to the rights of others. And that's the point. Thank you.
Thank you, Attorney Wall. Mr. Montero, anything else?
I think we've been over here about a year and 3-4 months. I think the project that I did has a lot of merits that I don't think a lot of people are even taking into consideration, or even the abutters. The project itself could have been twice the size. When they said I had no consideration for the neighborhood and everything else, I could have came in with a plan with 30 units. I'm coming in with 16 beautiful, nice capes and ranches that you're gonna have 4 affordable for the town, for people that are gonna be nurses, police officers, firemen, or whatever. The project did take a lot of consideration and thought. No one's ever discussed the merits of the project. I think the project speaks for itself. I could have come in like any of the other 40Bs and came in with twice the amount of density, and I didn't do that. The rights I have coming on my own property, I'm never saying that they're not gonna be able to use the road that's already there when it's paved. It's been there, that's fine. I have the right to come on my own property. I think I've met all of the aspects from the peer engineer over the last 7-8 months for what we've had to construct for either site views coming in, safety, and all of the other issues for a subdivision. I think of all your 40Bs, if you go look in town and compare what I have to the other ones, you're gonna see that all my houses aren't clustered one on top of the other. Most of the 40Bs, their units all have 4,000 square feet, 5,000 square feet. They're on half the amount of land that I'm doing. So I think I had a well-thought-out plan that would be a compliment to the neighborhood.
Okay, Mr. Montero? Okay. Board heard everything that we need in order to close?
I don't know if close or during discussion. There's been no request for continuation for additional submission of anything?
No.
I haven't heard any tonight.
Okay.
All right. Would anyone like to make a motion then?
Then I would make a motion to close.
Second.
Motion to close made by Bob, second by James. All those in favor?
Aye.
All right, hearing is closed. No more testimony may be taken. Fair at this point to have some discussion?
Sure.
Would anyone like to start?
I'll start, just, I'm not a voting member, but I think we still haven't resolved the question of access and whether a waiver is gonna apply, or what our authority is, what we can do at that A&R, given the attorney's language. I think that's still up in the air, and I guess the board has to decide now on the information in front of us. The waiver wasn't requested, no A&R note. The note wasn't asked to be removed, and there seemed to be a reluctance to submit a new A&R plan in accordance with the planning board or the subdivision regulations.
All right, thank you, Jerry. And to that, I'll add on to your comments. I know the board, we've had this project for, I think, 16 months now. To the applicant's credit, he has shown multiple revisions throughout those past 16 months. I think Attorney Wall stated that at one point, we started off with 6 waivers, and now we have 23 waivers in front of us. Still think that there might be some issues there that the board needs to address. But as far as issues that I have concerning this project, it does come down to safety. It does come down to health issues for me. I've heard many times that safety is usually an issue for me with 40Bs. I think with regard to specifics on this project, there's issues with site access, primary access, emergency access. Some of those issues with that T-turnaround were addressed. But then with access to the property itself, whether it's coming off Trotting Park Road and sharing access with Percival at that point, or where it merges, they call it a driveway since it's applied under a condo, but it really is a road. I think there are issues with site distance and ways to maneuver your cars, both at Trotting Park and at that point, off of where the development's proposed itself. Regarding the waivers, there are 23 waivers being proposed at this point. I'd have to look through them and see if there are any other waivers that are outstanding that weren't included. Jerry, you did mention that there is that outstanding issue regarding the non-buildable lot. We all know that the zoning board stands in for all the other boards in town, granting a comprehensive permit. We do have the ability to waive local zoning, but this board does not have any authority under state law. So with the arguments heard tonight, I'm not sure if I'm entirely convinced that we have the ability to waive that, especially since that non-buildable part of that A&R plan deals with state law. So those are my comments at this point.
Okay, so I think the biggest issue with this project was when they weren't able to get access to Percival Road. The original designs with straight driveways onto a street were just easier to deal with. The biggest problem the developer has is that a lot of things that affect this, like the line of sight distances, he doesn't control the sight distances. You know, we're dealing with questions of trees on other properties, or what if somebody else puts up a fence or not, but all of those are issues that do have safety concerns. I do like that they're larger lots versus some of these other projects, but, you know, the whole first portion of hearing this development, we heard it as a single-family ownership, and it kind of just changed overnight when, you know, one process didn't work, and then it's condominium ownership, and now we're getting rid of a road, and now we're going into a driveway, which brings up all the other waiver concerns. I have an issue as a condominium complex with the septic systems besides it being in a water resource district. I think when you're dealing with projects where you're dealing with affordable units, and you do have people that get into situations that may not be able, you know, when septic issues come up, they're very expensive. And if you don't have somebody that can repair anything, I do think it's an issue for the whole complex. I know they don't have to give us the home, HOA documents in advance, and they'd have to go to town council. But throughout the process, I asked questions about, how are they basing the fees, or how are the homeowner documents gonna be regulated? How are you gonna handle different things in the project? And unfortunately, the information just wasn't submitted, and you can only ask so many times before you just decide not to ask anymore. Regarding the T-turnaround, the fire department did say they were okay with it, as long as they could guarantee and protect that that area could never be blocked. Personally, I know what issues we've had in the past on other projects where we use signage. Signage just, quite frankly, doesn't work. If there was some kind of a gate access or something else that completely blocked off that area and the fire department had access to, that might be another situation that would help. Snow removal. There is only one place you can put the snow, and it's either gonna end up in the T-turnaround, or it's gonna be piled up on the end, and I don't even see how that's gonna work on the project. I think it could have been laid out differently. I think if you decided you really wanted to do this as a condominium project, you could have done cluster buildings, you could have done a different layout, you could have shared systems, you could have had something that I think might work a little better on the site, but, we can only review what's with us. So, again, for safety concerns, especially those line of sight distances, I'm very worried about those distances. When you've got the roadway, it's on part of his land, he has access to it, that's right, but, some of the arguments are, when it works, well, I can use it because I own the land, and then if it doesn't work, there's another argument that, well, they're using my property. There's too many questions. Now, I know our peer engineer didn't, but there were a lot of comments from our own engineering had same concerns with those areas. It's something as simple as, Jerry asked a question tonight about the trees, and he asked probably the most simplest question out of the whole project. If you know that your whole project is a pass or a fail for yourself with the removal of those trees, why didn't you find out who owns the trees, and why didn't you see if that's an issue or not? Because we heard here tonight that if those aren't removed, you do not have line of sight, period, and he does not have control of that property.
Mr. Chairman, if I may?
Sure, go ahead, Scott.
While there's such a great need for affordable housing, and we do need it in the town, but everybody leaves out the word, we need good projects and safe projects to make all of this work. Now, I think we've given the applicant and his team ample opportunity and whatever guidance we can put forward with respect to lowering the density, lowering the trips by density, things of that nature. And to be honest, at every point, and I know that I asked the question on numerous occasions, the applicant was unwilling to do that. And he said it wouldn't be affordable. So I feel comfortable with the fact that we tried on this one. We gave you every opportunity we could. It could have been smaller. There could have been things that have been done different. And we proved that we would work with you, but you were unwilling to change anything. So, that being said, Mr. Chairman, I would also be a no on this.
James?
I think, no, my comments are just gonna be duplicative at this point.
Okay. All right, so the voting members on this are myself, Bob Dugan, Scott Zelinski, and James Morris. Scott, did you have any?
No, they're very difficult projects. Mr. Montero's worked very hard. It seems like we're very close. The abutters have, obviously, with the line of sight and the safety issues and some of the other comments that the board members have made. It's unfortunate we can get down to 2 or 3 items and can't get it across the line. That's the unfortunate part where we seem to be today.
Thank you, Scott. All right. So that would leave us with a motion to, I suppose at this point, to direct Noreen to draft a decision then. So I would make the motion to direct Noreen to draft, I suppose, negative findings. for this project?
I'll second the motion, Mr.
Please.
Chairman.
Thank you, Scott. And Noreen, do you need any direction from the board at this point, or just based upon our conversations tonight and throughout the process? Would that be sufficient?
I think I have a pretty good starting point. I think, it's been a lot of material covered, and certainly for a draft, can certainly include all those items.
All right,
If there's anything specific that you want to identify, feel free, but I think, given the time that you're at tonight, certainly put that in a draft.
And then we get the draft at, what's the next date?
Probably have the draft ready in advance for May 5th,
May 5th.
so I can circulate it ahead.
All right, so I'll modify my motion, just asking Noreen to draft negative findings based upon conversations that we had tonight in preparation of our May 5th meeting. And Scott, that was seconded by you?
Yep.
All right, all those in favor?
Aye.
Aye. Okay, up next, we have application 16-21R, court remand. Noonan, 183 Surf Drive in Falmouth, requesting a special permit to raise and rebuild non-conforming dwelling, increasing lot coverage by structures. Voting members are myself, Scott Zelinski, Bob Dugan, James Morse, and Scott Peterson.
So, so the board knows there was a letter submitted to the file Tuesday from Kevin Clower, who represents 183 Surf Drive, Noonan, and he has asked, they would like a request of a continuance of the scheduled hearing. It was scheduled for tonight, Thursday, April 7th. It says the applicant's team is exploring certain construction methodologies that will hopefully address some of the concerns expressed by members of the board at the last hearing. While we have made progress in that effort, we'd like a chance to fully assemble the information and submit it to the board in advance of the next hearing. He was asking for the next available date, and the next available date that we would have would be April 21st. And I think Mr. Clower's here.
Mr. Clower's arrived.
Attorney Clower?
I really have nothing to add. Thank you for reading that in. 21st should work fine for us. I just wanted to make sure we can get you guys adequate information with enough notice.
Mr. Chairman, I'll move the request.
I'll second.
Very good, so motion to continue to April 21st, was it?
The 21st.
Okay, 21st, the motion was made by Scott, second by James, all those in favor?
Aye.
Aye, passes unanimously.
Thank you very much.
Kevin, I'm just gonna have you sign the extension just for.
All right, up next, we have application, onto our new hearings, I should mention, on to application 12-22, Buka Corp., 7 and 22, Nathan S. Ellis Highway in North Falmouth, requesting a modification of a special permit, number 23-88, to construct an addition and to allow the installation of an outdoor bar seating area. And
Okay, so application number 12-22, Buka Corp., P.O. Box 797, North Falmouth, Mass., has applied to the Zoning Board of Appeals for a modification of special permit 23-88 pursuant to sections 240-10.2A of the Code of Falmouth to construct an addition and to allow the installation of an outdoor bar seating area on subject property known as 7 and 22 Nathan Ellis Highway, North Falmouth, Mass.
Shall I proceed?
I'm just gonna read in the referrals.
You'll have to read in the referrals, Attorney Levitt.
So for engineering, the application was reviewed for impacts to public rights of way and public utilities. Nathan Ellis Highway is a public right-of-way in this area. No alterations are proposed to the right-of-way. Any changes within the right-of-way would require filing a permit with the engineering division. The plan shows that a walkway, ramp, fencing, and parking spaces are located within the public right-of-way on both sides of Nathan Ellis Highway. Permanent installation of objects not owned by the town located within the municipal right-of-way are typically require a license from the Select Board. The Select Board issued a license for this that was recorded at the Barnstable County Registry of Deeds in Book 34809, page 684. Any connections or alterations to public utilities would require permission from the appropriate town department. Project must not direct any stormwater runoff to public property, abutters, or public rights of way. We recommend that the board add a condition requiring the addition of dry wells for stormwater infiltration for the new roof area at a minimum. The address for the restaurant does not appear to be posted anywhere. We recommend the following condition be added, that upon completion of construction, the applicant shall post the address for the residence per subsection 99-1, affixing of legible numbers required and time limit for compliance. With the additional seats proposed, we would expect a parking analysis and plan showing that there will be enough parking spaces to comply with 240-14-1E, and that all of the spaces comply with 240-14-1G, including the ADA spaces requirements, in compliance with 240-14.1H and 240-14.1I, and all other applicable parking requirements that are under 240-14.1. The area labeled clamshell parking appears to be designated for accessible parking. Does this area comply with the regulations? We defer to the building commissioner if this surface meets ADA guidelines. And then just while I did that engineering, there was a correspondence from Chris Lephurst that said, after receiving the engineering referral, he wanted to make it very clear in the record that we are not adding any new seats, and therefore we do not believe parking is an issue. There's a copy in the file of the the license from the Board of Selectmen. And the license shows that, this will allow them to maintain an encroachment within the public right-of-way for a canopy over the deck, a ramp, a concrete walkway, a concrete slate walk, 3 handicap parking spaces, a clamshell parking area on the south side of Nathan Ellis Highway, Route 151, formerly known as Coonamessett Highway, and that's all being as parcel 1. On parcel 2, which is across the street, it allows them to maintain an encroachment within the public way for 16 angled parking spaces on the north side of Nathan Ellis Highway. And again, that's being parcel 2 that's referenced in the deed. There was a plan that was attached with the license. Conservation staff have no comments on the above referenced project as it appears to be located outside of Concom jurisdiction. Fire department has no issues with the project as drawn. From Kahalat Water, the water main and service must be on the plans to avoid temporary and permanent utility conflicts with the proposal. From Health Department, the septic systems on this property were installed under the old Title V regulations prior to 1995. I would not consider them to have any available capacity for more seating. Therefore, the number of seats should not be increased beyond what's been in existence. Health is fine with the reconfiguring the seating arrangement as long as the total seats remain unchanged. Record search in the building department showed the applicant was allowed to have 256 seats for some time in review of occupancy certificates, previous permits, and food applications. The existing capacity of 8,288 gallons per day is sufficient for the 72-seat function hall seats and the 184 full-service restaurant seats. Applicant does not need to come before the planning board as the additional square footage is minor in nature per discussion with the previous acting building commissioner, Eladio Gore. Assessors have no comments. There was a letter received this evening. This is from a Patricia Cusack, MS. Director of Sales and Marketing, North Hill Drive, Needham, Mass. Dear Town Selectmen, scheduling conflicts did not allow me to attend this evening's hearing, and my neighbor Jeff Fitzgerald has kindly agreed to voice my comments. My name is Patricia Cusack, and my property is located at number 16 Beeman Lane, which abuts the restaurant. I was recently contacted by Mr. Jarvis, owner of the restaurant, who generously offered to install trees along the property line to provide privacy for his guests as well as my benefit. Mr. Jarvis reported he was applying for a permit for outdoor seating. He explained because COVID was less of a concern, the town was reinstating its permitting provisions, and he was now required to apply for a permit for outdoor lunch and dinner seating. Upon review of the online application, it appears the permit is for an outdoor bar. At no time did our conversation to Mr. Jarvis mention an outdoor bar, only outdoor lunch and dinner seating. While I certainly appreciate the improvements made to the restaurant, particularly the outdoor area, I do feel the installation of an outdoor bar would have a negative impact on my property value. Further, the surrounding properties would also be negatively impacted by the increased noise levels. Beeman Lane is a quiet residential area, and having an outdoor bar would immediately change the look and feel of the surrounding neighborhood. I am not in agreement with the installation of an outdoor bar and would respectfully request a denial of this application. We did get a copy of one of the permits from the fire department that showed that their occupancy with the fire department was 256. And that's it. We also have a copy of the original zoning permit. There is something here from Scott Schluter. This was from Wednesday, March 9th. This was the referral on 12-22 Jarvis Edition Outdoor Bar. There's a PDF and grant of a license. He says, hello, ZBA. This one is a little closer to the deadline that we like because we've been discussing parking requirements in the zoning and planning for another project. And it isn't clear how they are applied to existing sites that propose expansions that require a parking space increase. I think planning was going to discuss the topic last night. I don't know if Jed can shed any light. We don't have anything that was submitted to the file. The existing parking for this site does not appear to comply with zoning. Does their proposed expansion that increases the number of required parking spaces require them to bring the site up to full compliance with the regulations or seek relief from them? There is enough room on this site to redo the parking area completely within their property with proper stall sizes, aisle widths, and ADA compliance. Does their proposed expansion require them to do that or seek relief? Regardless of what or isn't required by regulations, engineering has the opinion that a site proposing work that requires an increase in parking should be required to bring the site up to full compliance with the current zoning or seek relief from it. Simply put, if you add on to the site, the whole site should be brought up to compliance or granted relief from the requirements. And that's the only comment.
Mr. Chairman, I need to declare out of the abundance of caution, I did enter into a financial agreement in a sort with Bucatina. Approximately 3 months ago, we had my deceased father's after-funeral reception there.
Okay. If you do sit on this application, you feel that you could be objective?
Sure, they did a nice job.
All right. And for this, I'll be appointing Jerry as a voting member. And Attorney Lebhert's given Mr. Zelinski's disclosure. Would you be all right with him sitting on this application?
I would be delighted.
All right. All right. Go right ahead.
Okay, thank you. My name's Christopher Lebhers. I'm an attorney here in town, 99 Town Hall Square. I'm representing the applicant tonight, Buca Nominee Trust. We're seeking a couple of things at his property up in North Falmouth on Route 151. Before I go right into the project, I just want to introduce a couple of people here tonight, part of our team. The fellow with the blue hat on is Mr. Don Devaney. He's Mr. Jarvis's contractor. Fellow to his right is Mr. Jarvis himself, the owner of the properties before the board tonight. In the far back in the black sweater is zoning consultant Stephen McKenzie. He's working with us. The fellow with the mask on up front here is Dave Martin. He's our site engineer. And I don't believe we have any representatives from Rescom here tonight, the architects on the project. But we've got some pretty good plans that we've had prepared. I hope you find them to be satisfactory. We have them before you. We're here tonight, and although this application speaks to two parcels, all of the work that we're being proposed is on one parcel. It's a pretty well-known site in town. We're down at the far west end of Route 151, sort of on the corner of 28A. It's the Bucatina restaurant. Bucatina sits on the south side of 151. The parking area for Bucatina sits on the north side of 151. It's been in a restaurant, a nightclub for as long as anybody can remember. I think it goes back probably significantly longer than anybody in this room that's even been alive. It goes way, way back if you follow the history of the town of Falmouth. The zoning. The restaurant parcel, the Bucatina parcel, is zoned B2, has 27,000 and change for square feet. Fronts on Route 151. The parking lot across the way is actually residential B zone, has changed over 30,000 square feet. We want to do two things. We want to do an outdoor bar It's shown on your plans. We want to enclose an area to the south side of the restaurant building, enclose it and expand the kitchen. And all of those plans are before you. Initially, when we were determining what type of relief to seek, we ultimately went to see Mr. Gore. And he said, it's very simple. The property's already under special permit. What you do is you apply to modify the special permit. So we didn't specifically ask for this, that, or the next thing. He said, you're just modifying a special permit. He said, that's the only thing he asked for. I said, okay, you got it. The point that I probably want to emphasize tonight more than anything is we are not adding seats. We are not seeking any additional occupancy. We're significantly under lot coverage, both existing and proposed on the Bucatina parcel, and those calculations were on Mr. Martin's plan. I think we go from about 30% to 32% lot coverage by structure on the Bucatina parcel, and 40 is allowed. We are over lot coverage on the parking lot area across the street, but we're also a pre-existing non-conforming situation. That's a parking lot that's just existed for the longest time, and in fact, it was recognized by this board in appeal number 2388 that the parking is across the street. Interestingly enough, when Mr. Martin did his site work and prepared his plans, we did discover that we had some encroachments in the 151 layout, not on the pavement, but in the layout. That set us back quite a ways. We had to go through a hearing process with the Board of Selectmen, and ultimately we had to have plans prepared, and we were able to grant a license to make legal our use of some of that area in the 151 layout, and those papers are also on file with you. We want to do an outside bar, south side of the building as shown on the plans, 16 seats at the bar. We don't want to increase any other occupancy. Why do we want to do it? Well, COVID has changed a lot of things. Remember when COVID first hit a couple of years ago and everybody was doing the outside in the parking lots and so on and so forth, and it turns out people liked it. And I'm sure Mr. Jarvis can probably speak better to the issue, but the people liked it. And there clearly is a demand for this sort of thing. If you go to the site, you can see that Mr. Jarvis has attempted to fence it and screen it about as significantly as a person could. I was out there the other day, and it's pretty well screened. The kitchen apparently is in need of some additional space. Every once in a while when I'm out there, I actually see Mr. Jarvis with his apron on and his hat, and he works in that kitchen. I'm sure he can tell you better than I what the needs are for the restaurant. He also owns a couple of other restaurants that you may know. He owns the Quarter Deck across the street. He owns the Pilot House down there in Sandwich, and you know he's really done some wonderful things for our community. He's got a very loyal group of employees. And he really runs a very good business, and I'm aware of the CUSAC letter here tonight. But even she said it was wonderful that he came over, and he's doing everything he can to even appease her. Mr. Martin's site plan, the kitchen enclosure is 22.3 by 13.6, 303 square feet. The bar is 19.6 by 14, 274.4 square feet. So the total lot coverage increase is 578 square feet. And again, according to Mr. Martin's calculations, we go from, I believe, 30.5% to 32.6%. Sorry about the glasses. I used to be able to do this with the naked eye. Not anymore.
I hear you, Pete.
I think all of the plans are in order. I believe the application is pretty straightforward. Your contractor can answer any specific questions that might come up. I'm sure Mr. Jarvis would like to get a chance at the microphone if necessary. But we're here to answer any questions you have. I think the project is pretty easy to understand, even for a guy like me. So, have at it.
Thank you, Attorney Leibhertz. Board questions? Scott, anything?
Yes, Ms. Levers, just to clarify, 256 seats.
256 existing, 256 proposed.
Thank you.
Paul?
Yeah, Mr. Lippert, so my question is on that, and I know that we have the occupancy permit. Did you read the previous permit?
Did I read the?
The one that this is modifying at all?
I did.
Because that previous permit limited them to 165.
I saw that, but I'm also, you know,
So do you know when the change?
Well, I don't, there's clearly a discrepancy there, but the building department number has been 256.
No, I understand that. I'm not saying that anyone did anything out of, I'm
No,
just saying that we have to modify a previous permit, and according to the previous permit, and they broke it down, was 165. So if we went by the previous permit, we're already over by 43. And then looking for another 48. And the only reason I bring it up is I don't know if at that point, that's why they're looking at parking spaces and parking issue, because there was an increase that never came back.
There's clearly a discrepancy. I can't really explain how or why. I believe that that permit, the 1988 permit, was also, there was an enforcement issue there. If you read that permit, there were some conditions that were not being followed by the applicant and so on and so forth. Somewhere along the way, the town building department decided the number's 256. And that's the number that when I began to research the project, although I'm aware of the notation on the prior permit, to me, the town recognizes the number to be 256.
So as far as the permit then we'd be looking at this as a modification, just to change the 165 number.
To that end, yes. In
up to the
fact, if the record
256.
could be clarified on that, yes. We don't believe we are seeking additional seating. The number's been 256, probably been 256 since before Mr. Jarvis even acquired the property. But I do understand your point, Mr. Dewey.
So my only question was, so on the septic, is that where the metal access covers are in back? There was no septic shown on the plan, so I just didn't know if that was the access for the septic?
The location of the septic, I would, Mr. Martin is shaking his head affirmatively,
Yeah.
yes.
When you do the addition to the, and Mr. Jarvis can answer this after, when you do the addition for the kitchen, I noticed that's where the dumpsters or some other things are stored, so I assume that would have to be moved to another section of the site. So at some point, you could just let us know where that would be.
Okay.
And I noticed there was a lot of parking off that back end of the site, and probably because there just isn't a lot of space. So are you gonna be updating the plan at all to show the parking that actually occurs where the restaurant actually exists?
You're talking about the parking to the rear of the building?
To the side and the rear and
You know,
because I just didn't know if, does that
there
go to
is
lot
some,
coverage or
there's
no?
clearly some parking back there. I don't know whether there are employees that might park back there, but you know, as a general rule, the public doesn't seem to park back there. This board clearly recognized in the prior appeals that the parking was across the street. I guess.
Because if he needed that space for parking, that was the time to update the plan.
Well, again, looking at the submitted plan, we didn't show parking back there behind the restaurant.
No, so when I was.
But there is some space for some cars back there. There's no question about that.
And then my only question, but it would again have to go to septic unless the engineer knows. On the upgrade of the Title V, is that an H20 tank so they can park over the tanks?
I do not know if it's 10 or 20.
Okay, thank you.
There is a referral. The health agents seem to be satisfied with the system.
Yeah, I just don't know if he's aware there's actually parking back there or not, because it doesn't show on the plan. I mean, if it is, they could park somewhere else. It's just that if it's not an H20 system and they're parking cars on the septic.
Any condition that the board would put so as not to interfere with the septic, I'm sure would not be a problem.
If that's all I have.
We're not looking for problems. We're looking for solutions.
Thank you, Bob. Scott, anything?
Yeah, just a short one. Attorney Leibhertz, So you believe that the nonconformity, the pre-existing nonconformity in the parking lot across the street is protected by the original special permit?
It's clearly been recognized by the board, the very same parking in 88 that exists today. You know, it is what it is, and it seems to work. So yes, I would argue that it's a pre-existing non-conforming.
Easy, just for the record, that's all. Go easy.
It didn't seem to be a problem last time. I'm hoping it's not a problem tonight
I'm
because
just-
we're not looking for
Trying
more.
to verify your affirmation.
We're looking to
that's
do better business, not necessarily more.
all. That's all.
All right,
Thank
anything
you,
else,
Mr.
Scott?
Chairman.
Very good. James, anything?
Mr. Liberts, or Council, have there been any complaints during the outdoor dining period during COVID from any of the abutters that you're aware of?
I must be honest with you, I don't know. I can tell you, I go there every once in a while, I have zero complaints, but, Bobby, any problems with the butters?
No, there's never been any complaints, and,
You have to identify yourself for the record, sir.
Robert Jarvis, I'm the owner. We've never had any complaints.
What are your contemplated hours for this outdoor bar area?
The legal hours on the,
It would be whatever the selectmen give you for the liquor license.
liquor license, but we don't go that, we're buttoned up by, 11. So, we don't really, it's not a bar, it's a restaurant, so when service is over,
I realize a lot of the questions I have are, they kind of blend over into what the
I understand.
selectmen would exercise for the liquor license or entertainment license, but you're asking for an additional
legally,
use.
we're allowed to serve until 1, where we don't really make it that far, so.
I might also add that if we are fortunate enough to get through this process, we are going back to the selectmen. There's gonna be a change of premises on the liquor license, so there's some additional oversight on hours of operation and neighbors and all of those sorts of things.
I think some of our concerns, unfortunately, they blend together, because it is
Right.
a request for
Right.
additional use. Thank you.
All right, thanks, James. Jerry, anything?
A minor question. The additional bar, there'll be seating there, does that include the 256?
That is included in the 256,
Oh, thank
correct? Yeah.
Anything else, Jerry?
No, thank you.
All right, and my concerns have already been addressed through prior board questions, so we'll turn it over to public comment. Any questions, comments, or concerns regarding this project? Anyone at all?
Let me just clear my way out of here, Bob. Okay, thank you.
Yes, my name is Robert Manning. I live at 30 Nathan Ellis Highway, which doesn't directly abut Mr. Jarvis's property, but it's the third house down. There's the restaurant, Miss Cusick's house, Mr. Fitzgerald's house, and then my residence. When Mr. Jarvis says there has been no noise complaints, he may be right in that sense. Every now and then we do hear some noise emanating from what I would assume would be a wedding or a function in one of his rooms there. I know Mr. Fitzgerald wishes to speak to that as well. Mr. Fitzgerald's been down to actually bring that to his attention, and to Mr. Jarvis's credit, that's been mitigated. My concern throughout the whole process is, I haven't seen any plans, I didn't see anything posted online. I understand your numbers permit calls for 165, now we're going to 256. I understand it may traditionally have been 256. There is that discrepancy there. Parking is not necessarily an issue in the main parking lot, which is across the street, but you did reference parking either on the backside, which is where the employees park. If there were an extension to the building, and I haven't seen any plans, the plans I don't think are posted online unless I just missed them, but I haven't seen those type of plans. I think that would cut into the parking. I will give Mr. Jarvis credit. He has cleaned up that back area very nicely. The beach house that preceded him was, as we used to say, a bucket of blood. This place here is very, very well run. My main concern is the noise mitigation. How does Ms. Cusick, one of the issues I see there is she is directly abutting the restaurant. She's a new neighbor. She bought the house just last year, I believe. and noise could be a significant issue. I understand that, and Mr. Jarvis is correct, 11 PM is probably the latest that they go, but, you know, now with an outdoor bar, people hanging around, parking's an issue, noise becomes that much greater. So I would ask that, that we could maybe hear some noise mitigation. I don't know if he's planning on putting in more trees, or, I haven't even seen the extension itself, but those would be my comments right now. There is a private road, Beaman Lane does abut that restaurant as well. We haven't had any significant issues with traffic coming up and down that road. However, in speaking with the town, and I did send an email in 2015, it was blocked off at one point, and that may be something we have to go back to at this point if traffic and more people start using that back road. Thank you very much.
Thank you, Mr. Manning.
So just for clarification, just so you know, so on our main website, if you go to the zoning board site,
Yes.
there's a section that says plan review, and if you bring it up, it'll bring up all the addresses that we're reviewing, and all the main plans or stuff are there. So if you're ever at home and you don't want to come to the office, you can get basic information off of the plan review.
Very good, thank you.
Thank you. All right, anyone else?
Hi, my name is Mary Kerwin. I too live at 30 Beaman, or 30 Nathan Ellis Highway. And pardon my ignorance, because I've never attended these meetings, nor do I understand the procedure. However, I'm an attorney and Mr. Manning is an attorney. We just do a different kind of law, so we're not experts in this. However, what I would like to say, and I would echo Mr. Manning's, he said that Mr. Jarvis has done a good job cleaning it up, and I would say that. I've never met him, he's never approached us or talked to any of us on the road as far as I know. But what I would like to say is that I have huge concerns when Mr. Lebhertz gets up here and says, well, we're looking to re-permit this and we're going to do something different. If anybody looks at how close this restaurant is to our houses, it's nothing like the Courtyard or these other places. To now ask to open up a bar, and again, I will look, I didn't know, again, excuse my ignorance, I didn't know we could look the plans up, or I would have done that before I came here. But what I would like to say is that an outside bar with 16 seats, and as is, and I recognize that restaurants have struggles, and I recognize that COVID has impacted significantly on them. However, these houses will be hugely affected if we change and allow this place to turn. Mr. Jarvis said this isn't a bar. Well, if we open up a bar outside and allow it to stay open till 1 in the morning, I will suggest to you that those attract a great deal of people who like to stand outside and drink. And it becomes loud, it becomes noisy, and it becomes a real intrusion. As Bob just stated, there must be about 10 trucks up and down our road, and the town has told us that we can put a gate up, and we may have to do that. But I would like to work with Mr. Jarvis as far as like talking about this, because none of us we just got a letter from you, and so that's why we're here. I hope like a decision isn't being made tonight. I'm just asking for time to look at these plans that are there, and I hope this is not as quick a process as I witnessed earlier. I'd like more time, and if it's gonna be a big deal, then we might have to hire a lawyer who's an expert in this. Thanks for your time.
Thank you. All right, anyone else?
I'm Jeff Fitzgerald. We live at 24 Beaman Lane. I was the person who was going to read Patty Kusak's letter. Jarvis and Company have been a bonus for us on Beaman Lane. If any of you ever attended functions at the company that ran the bar prior to Mr. Jarvis's acquisition. Last summer, much to my surprise, because I'm retired and I spend a lot of time fooling around in the garden, mowing lawns, and in fact, I mow Mrs. Cusack's lawn. There was outdoor dining in the backyard, as we think of the restaurant. And there were tables, and there were people eating, and there were people drinking, I assume, alcoholic beverages, and there was a music system. So Patty's side, the fence between Patty's house and the restaurant is about this big, and then my yard is the next yard up before their yard. I never complained to Mr. Jarvis, but I did complain on a regular basis that during the day, there were two people dining in the backyard, beautiful summer day, with a sound system, an outdoor sound system playing music that my generation didn't like at all. So I was a music critic, but it was also impossible to sit outside in your own backyard because you became part of this party that was there. One day, I went over and I never ran into Mr. Jarvis directly there, but I asked who was in charge, and I said, we're listening to some of the worst music of the 60s being played out of speakers in your backyard, which is how I refer to the outdoor dining in the back. And I said, there's nobody eating there. It's 11:30, 12 o'clock in the afternoon. Thank you for the free entertainment, but we don't want music, and we have sort of a tunnel effect, because Beaman Lane's short, and there's very little difference between our houses. So I would ask you the question, do you want a bar in the house next door to you that's open during the day, serving booze, having music, all of that, and parking is an issue. Nobody can park on Beaman Lane. It's a narrow lane. Part of it needs serious work. We have to live. We accept he has a good business, and he's done a lot to improve the neighborhood. But they do bring in maybe 2-3 trucks a day, every other day, big trucks supplying the vegetables and the food and whatever else they're getting, and that has to come down Beaman Lane off 151, and it curves up behind the restaurant. Can't run a business without food and beverages coming in, but we have intentionally not arranged to pave the parking, the street rather. We have some nice big holes that we like them there because it seems to me the average driver for the trucks that make these deliveries is somewhere around 20, 21. And they have big trucks, and they think going 15, 20 miles an hour on this little road they're coming off 151, they make a turn, and here they are, and there's 3 houses here, and they're going to come into the backyard of the restaurant. And we've learned to live with it. You know, I'm retired, I'm home all day long, and the truck comes by, and another truck comes by, and the mailman comes by. It gets to be noisy. And the last thing we want to add to it, the environment, is more noise, more traffic, more anything. The parking across the highway doesn't have a real effect on me, except pedestrians who have to cross over. But when you're talking about additional parking behind the restaurant, I don't know where that comes from. The help, as far as I can tell, all park in the back of the restaurant. I don't see any more parking spaces being available unless, and I don't know if he has done this, but there's a property on the other side behind the restaurant. There's a little house and another business, a cartering business. That's the word. There's a little shop that makes food and delivers it. And then there is what I think is a little cottage that's empty. It's had tenants come and go. So I don't know where there's any more parking spaces in the back behind the restaurant. So that confuses me. And I think we're kind of surprised because this all came as a surprise to us. We saw a notice in the paper, in the Falmouth paper, that there would be a hearing. And Patty Cusack, I guess, had a chat with Mr. Jarvis. So we don't think we need outdoor drinking all through the year, a bar outside of the back. We eat there on a regular basis and take out food. It's a great place to be close to, except for the downside, which is the noise and the traffic and all that, but c'est la vie. But I don't see how you can have an outdoor bar when it adjuts a private home with this, maybe a little more room than that, and then
Sir,
mine, and then theirs.
Have exceeded your limit, but we do understand
I'm
your
sorry.
concerns.
I didn't know there was a
worries.
limit.
Points are taken.
Yes.
Sure, go ahead.
So you did make a complaint to Mr. Jarvis?
No, I made a complaint one night about 11:30, 12 at night. My wife said, you left the radio on or something, and I got up, and it wasn't. It was music being blasted through the outdoor.
Sorry, who did you make a complaint to somebody?
Yes, I got up, got out of bed, and got my bathrobe on, so the manager there will testify, because I walked into the restaurant in my bathrobe. I said, you got to turn your outdoor speakers.
Because there was previous testimony that there had been no complaints. I was just
No, it was
clarifying that
no
for the record.
complaints made to Mr. Jarvis. I didn't make any, I talked to the guy who was running the show that night.
Thank you.
And on a separate occasion, one summer, I think I mentioned, if I know there was a time limit, but there was a lot of noise and it was loud. There were nobody in the backyard, empty tables, and the speakers were on, and it was blowing sound up.
Thank you.
Sorry.
Thank you, Mr. Chairman.
Thank you for your comments.
So just for clarification, just so there's no confusion on the parking issue, so the parking I was referencing in back appears to be employees. It's not patrons of the restaurant?
No.
It appears to where...
I don't think so.
That appears to be where the employees are parking. I was just mentioning it's not on the plan, so...
Right. There are about maybe 6 positions, parking spots there, and they all look like the regular cars that are there. I assume they're employees.
Just a minute, Attorney Leverts. I just want to make sure there's no other public comment for tonight. All right, Attorney Leverts?
As I mentioned before, this isn't our last stop, if we're lucky enough to have this bar constructed and this kitchen addition. We go to the Board of Selectmen. Now, if you lived in this town as long as I have, you know that occasionally there are noise issues that come up in public establishments. And because of the nature of our town, we do have zones where you have business next to residence, and of course, there can be conflict from time to time. I have been involved with them at the casino, at the Brothers Four, downtown Falmouth here with residential abutters to the back, over at the Chappaqua Grill. Yes, of course, you occasionally see issues where there's noise and there are residential abutters. This parcel is B2, business. This is a business parcel. This is a business proposition that we are essentially proposing here. So there is a balance, but I want to say a couple of things to the abutters. We're not looking for trouble. Mr. Jarvis isn't looking for trouble. There are ways to limit hours of operation, and there is oversight. There's oversight from the Board of Selectmen. There's oversight from the building department. He can't just go out there and create all kinds of noise and be unreasonable and think he's going to get away with it because you folks gave him a special permit. It doesn't work like that at all. We all know that. I have no doubt Mr. Jarvis doesn't want any trouble here at all. He's going to be horrified if he's got neighbors around him that are unhappy with him, and I think he'd probably shut the whole thing down. That's the kind of operator he is. But there is oversight here. You know, when you have 256 people come in and it's a building open to the public, you can't control every single person every single night. There has to be some degree of being reasonable here as well. When you live next door to a business-owned piece of property that's a restaurant, well, you know, you're not living next to a residence. You're living next to a restaurant with the public can come in. So there is a balance. But all I can really say is I think Mr. Jarvis is reputation and business practices speak for themselves. He's just tops in this town. He really is. And I hope that buys him a little goodwill with the abutters, and I hope it buys him a little goodwill with the board.
I actually had a comment, Attorney Lebhertz. So, I mean, the board's familiar with this process as well. It's been many times that we've dealt with restaurants in close proximity to residential zones and dealing with requests like this. Tonight, can you speak to any noise mitigation efforts that you're willing to do towards the back? of the
Well,
property?
you know, the only thing I can think of would be hours, because you're outside. You know, noise mitigation inside is obviously an easier thing to do. I visited the site earlier in the week. I mean, I don't know where you do any more screening. I really don't.
And the butter's letter did reference something about trees.
If, I'm sure Mr. Jarvis would be happy to do anything more than he could do.
Yeah, so, I understand what you're saying.
Mr. Jardis, sorry, you gotta speak to the.
Okay,
the chair, to
those
the
speakers were put up,
Yep.
you know, last year with the people. Those things can come down, those things can change place, and I would do that for, you know, my neighbors for sure. The other thing is, you know, I do have a fence that goes around, a wooden fence. It was, a small metal fence along that other property. I can extend that wooden fence if that would help any type of noise situation for the neighbors.
Hold on a second. Mr. Chairman, would it be appropriate to offer the applicant a little time to maybe negotiate a little bit with the abutters prior to
So
the
actually,
next-
wanted an extension to work with the abutters directly.
Well, just so the board knows, we're gonna need an extension anyways, because, and this has nothing to do with Mr. Jarvis of the business, but we have kind of a real problem with the past permit. Because it only allowed the 165, and I know the occupancy was changed, we have to raise this now about 91, and that's gonna affect parking regulations. Now, I know we can waive certain amount of parking, but I don't know what the percentage is that we're allowed to waiver down. And right now, you have 75 parking spaces, and it appears they would need 128. I know we can get the numbers down, and there's 2 parcels here, so maybe that could be worked with, but we're gonna need some kind of an analysis only to clear up the prior permit, because in approving this, we are increasing it from the 165 to the 256.
So what you're saying, it's probably not a good idea to argue this right now.
I don't think we
until you have
can,
more
because
information.
the fire department deals on occupancy on the size of the building. Building department probably looked at size of the building. If I just had to guess, I would say nobody looked at the prior permit.
And I think that might extend from the fire in 88, I believe.
Well, this was in the fire in 88 is what they referenced for the exchange, and I think it's doable. I think it's doable. According to engineering, it might even be doable. But we're gonna need a lot more information on how we can allow the parking to make sure they can do the 256, so that everything going forward, if this is approved, doesn't have any more issues after that. It just straightens it out. And actually, and on the plan, when they redo it, they should just put some parking spaces wherever the employees are parking now. You can just show lines or something on a plan, just so they know what the spaces are there. And then on the same plan, they can show wherever the dumpsters and stuff are gonna be relocated when you do the addition to
Well,
the
those
kitchen.
won't be relocated. They're not gonna affect the building. So the
What-
building is just gonna be, it's just gonna go flush.
So what
Where
is
that
being,
indentation
what's being stored in there now? What's the other, it's not a
It's
dumpster.
outside
It's something,
area.
it's some other kind of, there's some kind of a, I don't know what it is. Is it a grease container? Some kind of big container stored there now. Is that something that could just be moved somewhere?
Yeah, well, there's 2 dumpsters. you
Yeah,
know,
so
regular
inside, so
dumpster,
inside the.
And then
Grease
behind
trap.
that is the grease.
It might be the grease trap, or.
Yeah.
And they can all be shown in a plan, but the board is gonna have to find out too, we'll have to look at the regulations, what is our maximum waiver if we do waivers, to get him down to what he needs for parking.
Could I add also that you should probably look to the selectmen's recent noise policy about outside mitigation? There's an extensive permit on a bar in the Heights you might be familiar with. And the other thing is, and I don't know, Noreen may come up with it, is this the parking come under a use that's been in existence for 10 years and therefore is grandfathered?
That's why I asked him about the protection on the previous,
So,
only because this is amended and not a change.
so I would get to Noreen, but, so uses aren't protected, right, just the,
Well, so you have a long-time use there, right? But I think
But not
they
under
do
a
need to
permit.
provide that they've got sufficient parking. And so they can look at the number of waivers that they're entitled to based
So
on
they're
the
not
volume.
entitled to a grandfathering that this has been in existence for 10 years?
My question, Noreen, is the intensity is now increasing in the outdoor use, and would they have to come up to code with the parking at that point?
That's what we're saying.
It's a good question.
If I could be heard on, you have to, again, go back to the history. If the truth be told, the parking is across the street, it's not even on the site. This is a unique situation. Generally, your parking is on your site. We're across the street. This is a long-term situation where parking for that building goes way back prior to 1988. I mean, I was looking at things from the 1920s and 30s, going that far back. We're under what I'll call it 243, but I know that we're redoing the numbers for the code. But the question is do we have a more substantially more detrimental use here? I don't know that I agree with you, Mr. Dugan, that we all of a sudden have to increase the parking because of that 188 issue. I mean, I understand your logic, of course.
yeah, no, I'm just going by, that's,
188 to 256.
it said that was the max indoor and outdoor was
Well,
165.
Mr. Chair, if we're gonna, excuse me, if we're gonna continue this, I think both sides knows what the issues are. It's probably better to
We
detail
were
it.
trying to flesh that out a little bit here, Jerry, yeah.
Well, I understand that
It's
there.
still going around the toilet,
I understand
think.
parking, I understand parking may not be up to code, but it's not going to be up to code, and it won't be because we're under a pre-existing non-conforming situation. I'm sure we can talk with Mr. Martin. I'm sure we can try to find a few more spaces
Just
where,
for number of spaces.
wherever
I know you
possible.
won't,
But we're not
get-
gonna conform.
Not to
know,
the
what-
size of the spaces, no, but at least when you're going from, and again, if this permit wasn't the one, if it had been modified at one time and nobody knew it wasn't modified, and this goes back to the town too, where one department does something without checking the other department. Whenever those hearings were done for this last permit, they didn't have to put in number 165. They specifically went in and threw a number in a 165. According to engineering, there's enough room. He thinks there's enough room to get at least spaces, and I think with a waiver we can give a reduction on that. I
Well,
just don't know what-
we'll take a look at it. I understand what you're saying. You want more parking. We're gonna have to look at the site.
You understand the benefit of lessening the nonconformity. I mean,
I
you've seen it
do.
1,000 times, right?
I do. What's going through my mind is the town's recognized us at 256, and we're not proposing any more. So I don't feel like we're really intensifying the situation. However, I understand Mr. Dugan's point about the 1988 permit, and I could talk to my client, and we can take a look at the site and see if we can find some more parking. I mean, like I said, we're not looking for any trouble here. We'll try to improve upon the situation in terms of parking.
All right, no one's accusing you of any trouble. I think
No,
we're just addressing
I
some
can find
zoning
trouble on my
issues.
own.
Better for the owner in the long
Believe me, I can
run.
find trouble on my own. I don't need it here. Okay?
All right, so we are looking at a continuance. What's the next best date that we have?
April 21st,
So moved.
if that's,
Is that
does
okay?
that give you enough time?
Attorney Lepers, enough time available?
I'm getting the affirmative head shake from my team, so I think the answer is yes, April 21st.
So then I'll make a motion to continue this to April 21st.
All right, so motion was made by Bob.
Mr. Chairman, that'll also give members of the community ample
look at the plans.
opportunity to review plans, correct?
Absolutely will.
Okay. Then
So
I'll-
I'll try to get a revised plan or any kind of a narrative that might help the board for that hearing, and course, I know the abutters over here pretty well myself. I'll see if I can sweet talk them some afternoon, too.
Very good.
Less objections, our decision
Yeah.
is much easier.
All right, so
Okay.
that motion was made to
Okay.
April 21st.
April 21st.
Was there a second?
Jerry
Yes,
seconded.
Second by Jerry. Thank you, Jerry. All those in favor?
Aye.
All right, see everyone back here April 21st. We'll take a 5-minute break. We are back on with our next new hearing. We have application number 13-22, Sacchetti, trustee, 461 Central Ave in East Falmouth, requesting a special permit to construct an addition and an accessory apartment above the existing garage.
Application 13-22, Karen W. Sacchetti, trustee, P.O. Box 745, East Falmouth, Mass. Has applied to the Zoning Board of Appeals for a special permit pursuant to sections 240-6.6B of the Code of Falmouth to construct an addition and an accessory apartment above the existing garage on subject property known as 461 Central Avenue, East Falmouth, Mass. For referrals, from Health, there were 2 permits for 2 systems installed circa 90 and 92. They indicate a combined septic capacity adequate for the proposed project. The planning decision indicates the overall project will not result in additional bedrooms. This is important as the accessory apartment bylaw IA requirement in a coastal pond overlay could be triggered if there was an increase in flow. Regarding conservation, above property is within conservation jurisdiction. However, we have not received a permit application for this work as of March 15th, 2022, so we need an update on that.
Can you repeat that, please?
So from conservation, so this is from March 15th of 2022, and it said, the property is within conservation jurisdiction. However, we have not received a permit application for this work as of March 15th, 2022.
Thank you.
And I didn't see anything in the file that was an update. On engineering, the application was reviewed for impacts to public rights-of-way and public utilities. Central Avenue is a public right-of-way in this area. No alterations are proposed to the right-of-way. Any changes within the right-of-way would require filing a permit with the engineering division. Any connections or alterations to public utilities would require permission from the appropriate town departments. The project must not direct any stormwater runoff to public property abutters or public right-of-way. Where this project falls in the jurisdiction of the Conservation Commission, engineering refers to the Commission for Stormwater Management and Construction Erosion Controls. The accessory apartment will require an address assignment. The engineering division will assign this when the applicant applies for the building permit. Based on the current addressing policy, the main building will remain as 461 Central Ave, and the accessory apartment will be assigned 461 Central Ave, Apartment A. We recommend the following condition be included. Upon completion of construction, the applicant shall post the address for the accessory apartment per subsection 99(1), affixing of legible numbers and time limit for compliance. From planning, the applicant received a site plan review approval from the planning board, and that approval has been attached to their referral. Fire department has no issues with the project as drawn. From the Assessor's Department, this includes Lot 1 through 14. And there was a road abandonment plan 236 /139. For Water Department, the water main and service must be on the plans to avoid any temporary or permanent utility conflicts with the proposal. They did attach a copy of the tie record card for comments. The existing service has a meter pit. The Falmouth Water Department requests that the pit be removed and the water meter be installed inside the home as part of the proposal. Any plumbing for the apartment must be fed from the existing home's plumbing unless a separate service is installed for the garage. They may not tie into the existing service to feed the new apartment. And then there was 2 correspondence. One is from, it looks like the applicant, Dick Sacchetti. It says, it appears that the Water Department has requests that they feel can be waived by the zoning board. I am requesting that it be done in light of the following facts. The water service to the existing suite has been there for over 20 years. The only water supply change to the suite is the addition of a sink. There is no change to the existing service that would require an upgrade of the meters, which is not a code requirement. There is no change in the existing site plan that requires their review. It would be helpful that the zoning board perceive this permit for what it is, the addition of a galley kitchen to an existing bedroom/living room, as did the planning board, and work with the homeowner.
Who's the author of that?
And that is the owner, it says Dick Sacchetti, but it's Richard Sacchetti who would be, I assume, the owner of the property. And then there is a response from Cathal O'Brien, who is the head of the water department. And he said, please note my comments stand, and we are not waiving anything but merely requesting a complete site plan as required. That's Cathal O'Brien. And there was an update done to the plan regarding the new steps on the side of the dwelling. That was sent over at 1:22 today.
That's revision 3?
Yeah, it's just.
On the site plan?
Yeah, just a slight revision regarding the stairs. That's it.
Alright, and Scott Peterson will be appointing you as a member, voting member on this one. And who do we have for the applicant?
Sorry.
No worries.
Hi, I'm Matthew Sacchetti. Karen, the property owner, is out of town. I'm here in her stead. I have nothing to add unless you have any specific questions.
Nice short presentation, we
Right.
like that. All right, so, stay.
You might wanna stay up there for a minute.
Stay up there, so we might have questions for you. We'll turn it over to board questions. Scott, anything?
So the change is for another 625 square feet, and you're adding the kitchen, is that correct?
That is correct.
Okay, to Bob's earlier point, there's been no permit application. Do you know the status of that with the Conservation Commission?
I do not.
Just on a lighter note, does somebody drive a red Corvette? In some of your renditions here.
I think that that particular vehicle spends more time in the garage with the hood up than it does on the road.
No further questions, Mr. Chairman.
Bob?
Actually, those are my same questions.
The Corvette?
No, well, I like the Corvette, but, no, that's all I.
All right, Scott?
If you're representing the applicant, I'm sure they're aware of how much we depend upon the referrals from our town department heads. And as you can well assume, a 20-year-old system gives us a good opportunity to upgrade the health and quality of that water line. Okay?
I don't think they were looking specifically for an upgrade, sorry to interrupt. I think what it is the.
They want it on the plan.
They want to have the surveyor added on to the plan, and I think their point was, typically, if you're adding an accessory apartment, they would ask for the separate water line, but what they're saying here is that there's already a bathroom existing.
They want it on the plan, so if they have to address any
Right,
issues with
right,
it,
right.
that's where I came in with the quality of.
Absolutely.
You wanna dig the guy's yard all up or
No,
anything else, they want
absolutely,
it as an
right.
as-built, if nothing else.
Right, but I don't think
Understand
they,
that,
I don't think they required an upgrade in the service itself. I think that was the
Maybe I
only point.
misrepresented what I meant. That's what I was looking for. I don't see why there was an upgrade, a revision on the plan today, and they didn't show where the water was going. It could have easily been put on the plan.
I can't speak to that, as, like I said earlier, I'm here just to represent Karen, who could not be here tonight.
Okay, thank you. Thank you, Mr. Chairman.
James, anything?
Not for the applicant, question for you. Have we ever
No.
taken off without a Concom, at least having it been opened or having a decision pending?
Not a,
I can remember.
no, not a Comcom, and the other question would be, and nothing against the representative, but I also have nothing in the file that said anyone else can represent them for the hearing.
This is gonna be a continuation, I think.
I don't even know how much further we should go with the hearing, because there's no.
I'm gonna move to continue at this point, Mr. Chairman. I don't wanna waste any more time on this tonight. I'm not opposed to the project, but it just seems that we're a little ahead of ourselves.
So when is that Concom hearing?
We don't know.
Oh, we don't know at all.
According to Concom, the last thing with Concom, they hadn't applied yet.
I don't think it's scheduled yet, was my understanding.
Oh, okay.
So just for your information, the land is under conservation jurisdiction. So even if the zoning board were to approve, you would still need approval from Conservation Commission as well, because they have control over that part of the land. So typically what happens is people go through conservation to get an order of conditions, and then they come to zoning. And I think for the board's information, sometimes what happens is sometimes applicants are hesitant to go before multiple boards if they feel that the zoning board won't approve their project.
hate to play it.
Sir, that's not what I'm saying at all, but the Concom also issues conditions because of the location of the wetlands and such that, that's their area of expertise, and we defer to their decision-making process because they deal with that much more often. So please don't think that I'm against the project at all, but procedurally, that's kind of what needs to happen.
So the clock doesn't start, we've opened it,
We opened it.
So,
but we have no indication on when or if there even has
right, so,
Concom hearing.
right, so you do have another option, which is you cannot approve anything that conservation would not also allow. In other words, they could not get a building permit without conservation approval. So you would also have the option, if it were your choice, to approve subject to conservation, and that if there were any changes made, that they would have to come back.
Yeah, I guess I would be in,
Because I
Agreement
don't
with
know how
James that
long
we
it
would-
would take for
As would I.
conservation.
Yeah, well, we have that conservation issue,
and I don't know who
I'm
represents.
happy you came tonight, but we don't have anything on record saying that he represents the property
Right,
owner.
so he can't even make an agreement.
We can't rely on the
For
answers in
condition.
case he doesn't know. So what's our next available?
It's a form you can get.
May 12th.
So then I would make a motion to continue the hearing to May 12th.
All right, so motion to continue May 12th, made by Bob,
And-
second by...
Yeah, and also to have the administrator just touch base with the applicant, just to let them know that if they can't be here, to make sure they have something submitted, that someone represents them.
All right, so that motion was made by Bob and second by Scott Peterson. All those in favor?
Aye.
All right, thank you. Thank you. All right, up next, we have application 14-22, SIPIC.
No.
13 Forest Ave in Falmouth, requesting a special permit to remove existing decks and construct an addition and a new deck.
Right, so application 14-22, Stephen and Christine Sypek, 21 Sunset Lane, Hingham, Mass., have applied to the Zoning Board of Appeals for a special permit pursuant to sections 240-10.2A of the Code of Falmouth to remove the existing deck and construct an addition and a new deck on subject property known as 13 Forest Avenue, Falmouth, Mass. We do have in the file from Conservation, determination of applicability. From engineering. The application was reviewed for impacts to public rights-of-way and public utilities. Vesper Avenue and Forest Avenue are public rights-of-way in the area. No alterations are proposed to the right-of-way. Any changes within the right-of-way would require filing a permit with the engineering division. Any connections or alterations to public utilities would require permission from the appropriate town department. The project does not direct any stormwater runoff to public property abutters or public rights-of-way. The dry well is proposed for the roof as we typically recommend. Erosion and sediment controls are shown on the plan, and they appear to be adequate to protect the public right-of-way. We recommend the following condition be included in any approval. Construction of this project shall follow the town's soil erosion and sediment control standard conditions, which could be found on the Engineering Division's page of the town's website. Any reference to Department of Public Works would be replaced with Zoning Board of Appeals, who's the permitting authority for the project. It appears that the hedge is located within the public right-of-way. Permanent installation of objects not owned by the town located within a municipal right-of-way typically require license from the Select Board. We defer to the Zoning Board of Appeals if this matter should be addressed prior to approval or just made as a condition as part of the approval. Health has no issues with this proposed project. For Water Department, the water main and service are on the plans as required. The existing water meter is in a pit. We recommend the meter be relocated inside the renovated home if there are plumbing improvements proposed. Otherwise, we have no further comments. Planning, no comment. This is the right, oh. One second. All right, so the first thing that I mentioned about the determinant of applicability, that is wrong. This project is not within conservation jurisdiction. This goes in a different file.
Good job, Bob.
Well, it was approved either way, so I guess. Again, fire department has no issues. And conservation staff have no comments because it is outside of their jurisdiction. There was a previous decision from the Zoning Board of Appeals, which is number 80-95. on 13 Forest Ave, and that reference parcel 3, lot 10. And there was a lot coverage bulk calculation submitted to the board.
Very good. All right, so we'll be appointing Jerry as voting member on this project, and for the applicant, we have a representative from Miller Starbuck.
Good evening, guys. So basically, what we're looking to do is, basically what we're looking to do.
Your name,
Oh, I'm
please?
sorry, John Sullivan with Miller Starbuck.
Thank you, Mr. Sullivan.
Basically, what we're looking to do is to remove 2 of the existing decks that they've had on the house, replace it with a smaller deck in one area, and a small addition where in place of the second deck. We've made some improvements to the drainage. The house has a walkout in the back, so the grade drops from the front to the back. So we've made some accommodations to collect that roof water, put it in a flow well. So there's, you know, on the existing house as well as the addition. We've decreased the percentage of nonconformity on the structures, decks, by a minimal amount. It's basically a wash between the decks coming off the smaller deck and the small addition going back on. In addition to those improvements, we've moved the deck on the rear side of the house to be more conforming to the lot line and the 10-foot setback on the back road side of the job, which is pointed out in the hashed decking on the back side of the property there, abutting Vesper Ave. So you can see the 2 decks that are outlined on the site plan if you have that. Do you want me to put the, on the screen for you?
If you could, that'd be great.
I'm just gonna use this before.
Oh, it's coming up. There you go.
There you go.
Just need to log in.
What do I have to do to sign into this?
Yeah, there's a password right up on top there.
Oh, I'm sorry. Go through?
I think you typed too much.
Excuse me?
You may have had too many characters.
On the right spot here. Thank you.
Pro forma, Mr. Chairman, we're coming up on 9:30, and I'll just make the preemptive motion to extend the board's business to 10.
Good
Second
idea,
it.
James. All right, so motion to extend the board's business till 10, made by James, second by Scott. All those in favor?
Aye.
All right. Might be just the one that has to keep it.
Yep. Let's see, site plan. All right. I don't know why this just keeps going. I hit refresh and it says we can't open this file. Something went wrong. I might need some more technical help here. I keep hitting refresh.
They should
it just
charge
goes-
us the second time. Yeah, charge you more money.
So that's one.
This is the existing I have up here now. I don't know why the proposed is not loading. Let me try again. Oh, here we go. So right here is, this is the existing deck in the black hashed out area. So we moved the newer deck over to be conforming to that 10-foot setback there. We're installing this dry well with, also taking care of all the erosion control. Like I said, there's a pretty good grade there, so we've taken into account any type of rain wash during construction as well as afterwards when we leave by tying the house into that dry well in the front. Like I said, we're almost awash on the, or we've slightly decreased our nonconformity on those structures, on the total of those structures there. We've accounted for the parking during construction. I think we got all the bases covered on this one. It's just, they basically want to trade 2 decks for a smaller deck and a small addition. The addition's, under 100 square feet, and what they're doing, they're not adding a bedroom, a bathroom, they're just opening up their kitchen. The house was built 60, 70, long time ago, so it's kind of like the old Cape Cod foundation size. I believe it's 24 by 30 or 24 by 31, somewhere in that range there, so really limited in their kitchen, so they're trying to just gain some square footage there, and in doing so, they've kind of sacrificed the large deck that they had in place of that. I think we're also, upgrading the HVAC to a more efficient system. We're adding insulation to the house throughout, attic, basement, there's some more moving parts to this to upgrade the mechanical systems as well as the envelope of the house. Just talking to the Cypex earlier tonight, they were saying it's probably been 50 years since somebody's updated anything on the house, inside or out, so I think we'd be doing the neighborhood a favor as well. We're doing a full exterior renovation on the house, trim siding, roof. That's about the gist of the project. We're gonna move some utilities coming into the house, but it's all pretty standard stuff.
Would you turn it over to board questions then?
Excuse me?
Would you like to turn it over to board questions then? If
Absolutely.
you're all set with your presentation? Sure. All right, Jerry, anything?
Not at this time.
James?
No questions, thank you.
Scott?
Just a clarification, do you have any idea what, you're going from elevation 28 to the south with your dry well, and it drops off pretty good in the back. Do you know where groundwater is, what elevation groundwater is?
I don't know off the top of my head what the elevation of the table is there.
Because you lose 2 feet through the structure towards groundwater. I was just
Yeah.
curious if you guys knew.
I'm not sure where we are in groundwater. I knew we were well over the floodplain. I didn't even look into the groundwater.
Okay. Just a question.
Yeah, no, I wish I
just
could answer it
curious.
for you.
Thank you.
I didn't.
Pretty high elevation.
So with the new kitchen, you'll be doing plumbing improvements?
Yes, plumbing improvements on the inside. Most of the house, we have a bathroom we're gonna be renovating on the second floor. That's gonna require replacing the roughs and the waistlines down
So-
into the basement.
So at that point, just be aware that they'll have you relocate the pit, the water that's in the pit, they'll have you put it to meter inside the house.
Okay, yeah, I saw the
reflected
note
on
on
the
the
plans.
engineers.
And I don't think it is, but I'm just asking, you may not know, this isn't involved in historic at all, correct?
No. No historic, no conservation, no floodplain.
Just more on process, on your lot coverage bulk calculations worksheet, you listed 13 Forest Ave twice at 4,800 square feet, yet the lot size is 5,578. I was just wondering which is right.
Are we talking about on the site plan here?
You have, yes, you have two different numbers here, and then on your bulk calculations worksheet, it only shows your lot size at 4,800 square feet.
Do you want the actual? So the engineer's lot coverage is 5578 square feet. I'd be,
Yep.
right, defer to that over anything that we had calculated in the application
Okay.
process.
That's fine.
So,
Thank you. No further questions.
All right,
Thank
thanks,
you.
Scott. Sure. Absolutely.
Yeah, so I have a question actually for the administrator. So the previous property, and I knew it wasn't historic, but it is on the inventory list because it used to have there used to be a store in that. I remember doing history on it once. There was a store in that garage. So we could just list in there in a finding that it's on the list. They're not demolishing or moving the property, but if.
Yeah, I did inquire with Historic, and what they said was if it's not being demolished or moved.
It's okay. Yeah, we'll just
And
put
they
it as a
don't-
thing, as a finding.
All right. Questions that I had were already addressed through board questions, so public comment. Does anyone have any question, comment, or concern about this project?
Chair, make motion close.
All right, motion to close made by Scott.
Second.
Second by James. All those in favor?
Aye.
Aye. Passes unanimously. Hearing is closed. No more testimony may be taken.
Motion to approve the conditions.
Second.
Motion to approve the conditions made by Bob, second by James. Findings?
So 240 10.2A, 240 12.1E, they're going to be removing 2 decks and adding a deck. They're actually doing a slight reduction in the coverage on decks, but it's de minimis.
Addition of a dry well.
Yep, they're adding a dry well. They will be relocating the meter. They'll be getting rid of the meter pit and relocating the meter in the basement of the home because they will be doing plumbing improvements, including the kitchen and the baths. It's in a residential C zone. Property is not historic, but is listed on the historic inventory list, which only gets triggered if the property is demolished or removed.
All right, does that do it for findings?
There's not
Did
too
you cover
much.
there's no increase in nonconformities and some improvement as to the setbacks?
Mm-hmm.
Yeah, you can list the sidelines from the plan, place that the hedge is in the town row layout, and they would want to get a license from the select board to keep the hedge in the road layout. You can also make that as a condition.
All right. Should we move it on to conditions then?
Yeah, just, like I say, per plans, construction hours. Probably in this location, they probably won't be able to keep everything on site, so they'll have to regulate something with police.
There's the height.
Condition that they get rid of the meter pit and relocate the meter in the basement. Actually on a finding too, add the referral from the water department regarding water lines, if anything was changed later on. Soil erosion and sediment control standard conditions. Yeah, I don't think there's too much, it's kind of a minor change.
All right. Anything else for conditions? Anyone at all?
Good.
All right. All right, so that was a motion to approve with conditions made by Bob and second by James. All those in favor?
Aye.
Aye, passes unanimously.
Thank
For
you.
your time tonight.
Thank you.
There's a really cool store in the garage.
Yeah.
The old photos. Like a really cool, like an old general store.
All right, up next, we have application 15-22 Cushing, 90 Nantucket Ave in Falmouth, requesting a special permit to construct a half-story addition to the non-conforming single-family dwelling, creating additional living space.
Application 15-22, David P. and Wendy Cushing, 5 Sullivan Terrace, Framingham, Mass. have applied to the Zoning Board of Appeals for a special permit pursuant to sections 240 10.2A and 240 11.3A4 of the Code of Falmouth to construct a half-story addition to the non-conforming single-family dwelling, creating additional living space on subject property known as 90 Nantucket Ave, Falmouth, Mass. Referrals. Okay, so this is from Amy Lowell at wastewater. I think the game room would be considered a bedroom for Title V purposes. It has a door, windows, and a closet, and is in fact large enough to accommodate several beds. However, it is only one room, and there are 3 existing bedrooms in the house, so even if you do consider the game room as the 4th bedroom, this addition does not require variance under the flow-neutral bylaw, which allows up to 4 bedrooms by right on the LPSSA system. There is a determination of applicability from Concom. And Concom has approved the above referenced project through a negative determination under a request of a determination for applicability, and all the plans are referenced. At the time, the permit wasn't available, but it seems it is now. Some engineering. The application was reviewed for impacts to public rights-of-way and public utilities. Nantucket Ave and Elysian Ave are public rights-of-way in this area. No alterations are proposed to the right-of-way. However, there appears to be several unpermitted alterations to the driveways within the town right-of-way since 2011. We requested that the applicant file a driveway permit to cover the unpermitted work. We would also not approve the apron extensions as constructed. Either this must be removed or modified to provide a full-width parking space 9 feet, and this can be covered in the driveway permit. The engineering division will not sign off on a building permit until the driveway issue has been resolved. We defer to the zoning board of appeals if this should be resolved prior to the issuance of the special permit. Any connections or alterations to public utilities would require permission from the appropriate town department. Project must not direct any stormwater runoff to public property, abutters, or public rights-of-way. Dry wells are proposed as recommended. Erosion controls are proposed to protect the town right-of-way and abutters. We recommend the following condition be included. Construction of the project shall follow the town's soil erosion sediment control standard conditions document. References to the Department of Public Works Engineering shall be replaced with the Zoning Board of Appeals. It appears that cobblestone edging and landscaping are all located within the public right-of-way. Permanent installation of objects not owned by the town located within the municipal right-of-way typically require a license from the Select Board. We defer to the Zoning Board of Appeals if this matter should be addressed prior to any approval or as a condition in any approval. And with all of the referrals, engineering has supplied photos. Assessors has no comment. Planning has no comment. From Health, property is on town sewer, so Health doesn't have any issues and refers to wastewater, and we already have wastewater. From Cathalat Water, the water main and service are on the plans as required, and the existing home has town water service and currently meets the Falmouth Water Department standards. Fire Department has no issues with the project as drawn. There's a lot comparison worksheet that's been submitted. I think also a,
And they were the first ones here tonight.
yeah, sorry.
Thank you for your patience.
Well, I was the first one here, you were the second.
There was a few more worksheets on this one, right? There was one, right? Yeah, I didn't see it right away, and I thought I read one. So a FEMA worksheet has been supplied, based on the assessment of the property. That's it.
Anything else? That's it? All right, great. Scott will be appointing you as a voting member on this one.
Thank you.
And Jerry, are you on the abutters list for this project?
Yeah, I'm right around the corner. I probably am on the abutters list.
Also, before we start, yeah, sorry. So there was a previous decision on the property, 94-06. And, leave the list in here? of the-
While he's doing that,
The
should I
abutters is
recuse
in the
myself from
front.
some of the butters list, but I have
Yeah.
just an oral, okay.
Yeah, no.
Yeah,
no-
not well, whatever you want to.
Well, disclosure.
Disclosure, yeah.
And if you want to recuse, then that's.
Yeah, I don't need a recuse on.
All right. We'll circle back on that during
The abutters letter and the
board
list of,
updates, I guess.
things that
I
we
got
did
an
from the original
email from Newtown Council that's giving us some new advisory opinion about.
Oh, okay.
That, but I got that too late in the day to really
Goes through all the changes.
look through it, but I'll bring it up during board updates. But as long as we get on record that you're on the, you've been notified as an abutter and that you disclosed that.
My attorney
Scott's-
discloses.
I guess
Scott's a
I was
voting
looking
member
for
on
the,
this
was there
anyway,
a
so
letter
we
from
should
the
have a
abutter?
problem.
Oh, I'm sorry.
No,
I
I
already
don't
had the
think
butters
so.
list.
No.
All right, so regarding the previous decision, which was 94-06, so just so the board knows, there were discrepancies from the original decision to the current conditions. They allowed an increase in lot coverage from 20.04 to 24.95%. The existing shed was to be raised and not constructed. The overall lot coverage was 36.9, height 27.1, what exists is 27.8. No more than 3 bedrooms, but that's sewer now. Lot coverage by structure was not to exceed the 24.95. The rear stoop to leave the property was not to exceed 4 feet 4, and that one's 4 feet 6, 7. Shed was removed, but it shows that there are other storage structures on the property. And the lot coverage, the 49.7. So the overall lot coverage was set at 36.9, and it looks like it's 49.7. And the 24.95 is actually 29.51. The non-conformity to the street was 11.7, 9.5 to the sideline, and 4.9 to the rear. So those are the differences from the original permit we'd have to check on.
All right. All set then?
Yeah.
All right. Attorney Clower?
Good evening. I'll do my best to be brief, because it is late. For the record, my name is Kevin Clower. I'm an attorney with Ahmed Clower Law Firm here in Falmouth, and I represent the applicants, David and Wendy Cushing, the owners of 90 Nantucket Avenue, and the applicants in this matter. I'm here before you tonight seeking permission for them to alter the existing non-conforming dwelling at the site. This property, 90 Nantucket Avenue, is located on the eastern end of the Heights, just 2 houses removed from Little Pond. As this board knows, it is a very dense, very seasonal neighborhood. This lot is, I think, very typical for the area. It's 3767 square feet, RC zoning district, and in an AE 13 flood zone, and it is on the Little Pond sewer. Presently, there's a 3-bedroom, single-family dwelling with a footprint of approximately 1,113 square feet. This property is non-conforming to the front yard setback, 11.7 feet where 25 is required. The rear yard setback, 4.9 feet where 10 is required. The side yard setback to the east being 9.5 feet where 10 is required, as well as lot coverage by structure being 29.5 where 20% is allowed by right and 25 by special permit, as well as lot coverage by structures, paving, and parking, where being 49.7 where 40 is allowed. The applicant's family has owned this property in various forms over the last 42 years, and have made consistent use of the property over that time. It was rebuilt in 2007, and that house is still in good condition. However, the applicants are seeking to create an addition which will improve the habitable and usable space within the property. This proposal is a half-story addition, which will serve as a family room/den. It's additional usable space. It's entirely within the existing footprint. There's no impact of this on the existing nonconformities, neither the lot setbacks nor the lot coverage percentages. The existing ridge height is 27 feet 8 inches. This will increase to 33 feet 1 inch, which is an increase of 5 feet 3 inches. Still below the 35 feet allowed by right. As was noted in Ms. Lowell's referral, this new room technically meets the definition of a bedroom They don't intend to use it as such, however, it is allowed as a by right matter because it is on the Little Pond sewer connection. Pursuant to the building code and FEMA regulations, a cost breakdown worksheet was submitted showing that the proposed work is less than 50% of the town's assessed value. Therefore, it's not a substantial improvement as defined. Due to the existing nonconformities, this does require a special permit under sections 240-10.2A and 240-11.3A4, previously 243C and 240-69E respectively. Under 240-10.2A, the board may allow alterations to pre-existing nonconforming structures when there's a finding by the board that the proposal is not substantially more detrimental to the neighborhood than what exists. In order to consider this, you're asked to look at the standards of 240-12.1E, formerly 216, and whether or not the alteration creates any new dimensional nonconformities, impairs views and vistas, and reasonably conforms to the neighborhood. In this case, there's no new nonconformity created. The existing nonconformities are unaffected, and there's no impact on the lot, setbacks or lot coverage. The proposal remains consistent with many of the surrounding homes. Under 240-11.3A4, lot coverage by structure exceeding 20% is allowed, and the board's asked to consider the size and height of the structure in relation to the average size and height of structures in the neighborhood, the effects of shadow on adjacent properties, the impacts on views and vistas from public ways, and the effect of nitrogen on coastal embayments. This proposal has no impact of views and vistas from the public ways. The effect of nitrogen on coastal embayments is incredibly limited because it is on the sewer system and the allowed number of bedrooms. There should be little change to the effect of shadow. Again, this is a dense neighborhood with an only minor increase to ridge height. As to size and height of the structure, we did submit that lot comparison worksheet for nearby properties. This, again, is a very dense neighborhood, most homes being on similar footprints and lot sizes, with most of the homes having very similar dimensions. Of the 39 houses that we looked at within a 300-foot radius, 18 of them had a larger gross floor area, and 22 had larger footprints. As proposed, this is almost exactly at the median of the neighborhood. The comparison shows just how similar the neighborhood is to the proposed project, both to the subject property, both as existing and proposed. We did receive the referral from engineering. We submitted a revised plan, which is before you right now. In response, a portion of the existing driveway, that cobble strip that they referred to, is proposed to be removed. There was some communication with the engineering department, and they didn't want to issue a driveway permit until a license was obtained. And because we had this chicken and the egg situation, what I suggested was we come before the board tonight, if the board's so inclined to approve it. It could be conditioned upon both a license from the Board of Selectmen for what's to remain, as well as a driveway permit from engineering, which is a requirement of any building permit anyways. I did note some of the discrepancies that Mr. Dugan pointed out from the existing, from the original special permit. I don't know how they calculated lot coverage at that time in 2007, but when I took a look at what was included here today, when you looked at the stoops outside, so this area here, up here, the rinse station, which is shaded as to be included, as well as the shed, that is almost exactly the discrepancy in square footage. So I don't know if they simply didn't include the stoops in the square footage in 2007 when they calculated that or not, but that is almost exactly the square footage discrepancy for lot coverage by structure.
So what you're saying is it's the side bins,
The side bins, it's 113 square feet is the difference.
Okay.
And when I did the math on the side porches, on the western side, the northern side, the rinse station is shaded as to be included. If you look down here, there's a little key which talks about areas shaded that color are included in the calculations in this case. And I know normally we don't include rinse stations, but for whatever reason they did. When you include that in the shed, that is almost exactly the square footage discrepancy between what was approved and what is before you tonight. The applicant's proposal, I think, will be an improvement for the applicants. It will do so in a way that does not negatively impact the neighborhood. There's no impact on the existing nonconformities. We're not creating any new dimensional nonconformities. There's no adverse effects that overbalance the benefits I've described. And as of detailed, I think this is in character with the neighborhood. For these reasons, I believe it meets the requirements of 240-10.2A, 11.3A4, and 240-12.1E1. I'd be happy to address any questions that the board might have, but I think that this is relatively a fairly small project that doesn't have any negative impacts here.
All right, thank you, Attorney Clower. Board questions? Scott, anything?
Again, maybe just a little hung up on process, Attorney Clower. In the document, we have the size of existing structures, 3 bedrooms, footprint of 1,113 square feet. The proposed structure is single-family dwelling with 4 bedrooms with a footprint of 1,113 square feet. In the brief, it says the applicant proposed renovations that will add a half-story to the structure and provide additional living space. So why hasn't the total square footage changed?
So that's the footprint. That 1,113 is the footprint, not the overall gross floor area.
Okay.
The gross floor area increase is shown on the lot comparison worksheet. And I believe that is a change of,
True. Okay, gotcha. Sorry about that.
actually I don't have that additional number there, but we can find out the exact square footage of that new room. But the overall footprint is not increasing.
My bad, yep, correct. And then the ridge height, you said, is 33.1?
33 feet 1 inch will be the
okay.
proposed ridge height.
And you spoke to the driveway permit. Okay, no further questions.
All right, thank you. Bob?
Yeah, so Mr. Clower, so where from the last permit and this permit, they all increased well over what we would be allowed to give as a special permit. Are they amendable to adjusting or removing, or, I mean, because you've gone from, the original permit was 24.95, knowing that we couldn't go over 25, and now they're over 29.5.
So I don't know the answer to that question in this moment. I think if anything were to be changed, potentially the shed, and I think the rinse station could not be included, because I think typically we don't have that included. That would adjust the numbers. I think it gets it to, I was running back at the envelope calculations.
I'm just trying to see how close we can get to the original.
Yeah, I think it gets it to like 25.4 without those. I'm not sure I've looked at the aerial photographs. I didn't see any significant change in hardscapes here over the last 10 years, so I don't know what.
No, I think the only other difference was what they eliminated whatever that back stoop was to a 4x4, and I think they added another couple of feet.
Yeah, and it looks to me it's 6.7 by 4 and change.
I don't have as much concern with that because it's an entrance, so.
Yeah. So I don't know about the shed. I suspect that there's not much storage here, and they have that shed to address that, but I understand the board's concern.
And you'd mentioned that the apron that goes along the front is the one that they're already planning on removing?
Yeah, so this hash marks that apron and cobble edging to be removed.
Okay. That's the only question I have.
All right, thanks, Bob. Scott?
I would certainly agree that it's always beneficial to tell the egg that the chicken's all right with the program, right?
I'm not sure I follow that, but I'm going to say yes.
It was your reference, not mine. You made a reference to the chicken or the egg with respect to conditioning this permit. It's always easier to tell the egg that the chicken has no problem when you're asking for permission, right?
So, I'm not saying there's no problem. I think we have to have it addressed, and the engineering department's made that clear to us. Doing what we're proposing will address it. The team from Longfellow did reach out to engineering, but they basically said, we don't want to, we're not going to issue a driveway permit until you deal with a license. And I didn't want to apply for the license knowing we were so close to the hearing for this.
No problem. Thank you.
All right, James?
No, my questions have been addressed, thank you.
Jerry?
You did do math in law school, right?
I went to law school because I'm not good at math, Jerry.
Okay, so math.
Same here.
So you could be off on your .5.
I could be off on my .5, but I've done more math as a lawyer than I ever anticipated doing.
Thank you. No further questions.
As IELTS accounts are tricky.
All right.
Those are, there's neighbors in the audience.
What's that?
Those are neighbors.
Oh, okay. I don't have any questions myself. They've already been addressed, so public comment, any questions, comments, or concerns regarding this project? Assume you two are in favor?
Yeah.
We live directly next door to him.
Give him your name.
Oh, my name is Barbara Malowitz. This is my husband, Wesley Malowitz.
I'm Wesley Malowitz.
Yeah. and
We live at number 4 Elysian,
Right next door.
which is.
Is that
if you look at
behind
the
it at the top?
backside,
Okay.
And the distance from our house to their house,
It's less than 10 feet. And
It's-
we can look from the door of their house into the window of ours. And they wave.
when that house, we've owned our house since 1981. So we're very familiar with the previous house.
Yeah, his mom and dad.
And both our houses were relatively about the same size and height. And when this house was built, we had approached the Zoning Board of Appeals directly, and we were told that at that time that there was nothing we could do to prevent it from happening. When the house was built, I'm gonna be 79 this year, my wife is 77. So, when the house was built, okay, we can't even look out our window without seeing a monster structure.
Just show you the house that they are going to.
Maybe you're gonna have to give that to the clerk.
Yeah,
Ma'am?
if you want to submit it to the file, you can give it to
I'll
the
put
clerk.
it actually in
here.
the file so everybody can see it. Let me just stamp it in.
If you look at where I've marked this mark, this looks into our bedroom, and these two windows look into our living room. The kitchen is one, and then the other is our bedroom. And
Ma'am, you're gonna have to finish your
Sorry.
testimony so the TV audience can hear you.
It's
we're not
very
gonna have any sun at all. That is in the front of our house. What you see on the side is what we are going to see in our house that's that small.
And they're adding a third story onto the house, which is gonna overshadow us
We won't have any sun.
and give us a sense of no openness. In other words, we bought the house in 81 as a future retirement for us. And now we're at that retirement, well, we're retired. We just recently sold our house, our primary house, and now we're gonna be moving to the Cape. And this is what we're gonna be seeing every day.
But I can't believe that it's not even a 10-foot difference in our houses because of the way it was when we bought our house. It was in a different, they didn't have all these variances. And so you'd walk out your door and you're right there. We had to put up a vine to cover up so we didn't have to look at the door when we had our curtain up in the morning. And they already have a beautiful McMansion.
They have
And
a
I don't
beautiful
begrudge
home.
them. But the fact remains is we've gotten over the fact of them looking in our living room and being able to look into the bedroom. But to put this on and block the sun in our porch, it's like, you have to go and look at it. Now, if you look at the other side of the Cushings, there's a house that they have a driveway right on their side and still part of the Cushing land. So they've got enough distance that it doesn't matter to them. But to us, it matters. We're gonna be completely blocked off. And then when you were mentioning a 6-foot fence, I remember when they built it, and they had the 6-foot fence, and then they tapered it down to go to the front, because his mother, Gert Cushing, told him that the neighbors did not want to be blocked from being able to see down the street. And thank goodness they listened to her, because at least we can see the intersection and everything. Before that, I mean, if they had put a 6-foot fence, we would have been completely blocked out. I'm not saying they're bad people, but I think people begin to think that they're the only ones that count. I come from a time when we ask people if they want us to do something, or if we want to cut a limb off a tree, we ask them first. Everything we've done has been honesty, and I just
Have
get
you been
so
approached by anybody from the Cushings or their?
No, nothing.
You've had no
Until we
dialogue
got
with them at
the-
all?
No, nothing. And it's just frustrating, because it just seems like the world's turned into a very, selfish world, and I just can't handle it. So this means a great deal to us if you just listen and hear. If 3 bedrooms in a house like that is beautiful. I love the house.
It's a monster home.
But to put a game room and another bedroom on it, I'm like, wait a minute, you're pulling us right into the dark. And as it was when the house in front of us, off to the side of, the other side of us, when they bought the Sue Manzaro's house, they thought that they owned right up to our garage. They came, took the fence down, put the machine up on our driveway, and dug the whole side out. They didn't know that that was our property. The guy had to come in and fill all our land. So we have seen it, even in our garage. We used to be able to see the pond. They put a shed up in back of us without asking us. So I feel like it's just we've been just kind of like thrown to the curbside. I just can't see the need for them to have another room. I really can't. 2 rooms. I hate losing the sun, and I feel like I'm gonna be completely boxed in. So that's my issue, and I've waited long enough all night. I've been patient, tried to be patient.
Certainly have been.
But I really, really need for you to think twice whether this is a need. This is their second home, too. So, I mean, it's a perfect 2 or 3 bedroom, 2 bath, I don't know what they have upstairs, but it's a perfect place for them, and they've got it all brand new.
I want to thank you.
happy.
I want to thank you for your patience tonight, and I have been a little generous with the time.
I'm glad
Yep.
that you have. At least I feel we've been heard.
Of course you have.
I just
Bob
have-
has a question
I just
for
have
you.
one question, just because you live there and you observe. Have there been any issues with parking?
They've used our driveway a few times, and we've...
No, but I mean so on that site, do they usually keep the cars on the site?
On their site, yeah.
Yeah.
Yeah, they're good like that,
Thank you.
yeah.
All right. Thank you for your comments tonight.
Thank you, I appreciate it. Good night.
All right. Attorney Clara, do you want to address any of the issues that the abutters have brought up?
I certainly understand, their concerns. I think a lot of the issues that they raised didn't necessarily deal with the Cushings. They mentioned things with the neighbors in the garage and the fence being improved. And while I understand their concern over the ridge height, we already have a horizontal ridge height running east to west on that site, and we're talking about raising it 5 feet. We're not talking about a dramatic change here. I don't think that this is going to blot out the sun as they may feel. I'm glad that Mrs. Malowitz thinks that the house they have is enough for them, but they don't feel that way. So that's why they're here tonight seeking approval to make an addition. It's a 1-room addition. It's a game room, which is also counts as a bedroom. It's additional habitable space. It is a relatively small footprint of a house. There's not much in the way of common gathering area, and that's what they're asking to provide.
Thank you, Attorney Clara. Any other follow-up questions from the board?
Attorney Cloud, do you think that shadowing is a nuisance?
I think
Perceived shadowing?
I think shadow is a factor that the board can consider. I think that, I've been to the site, ma'am. I visited the site just today, actually, and I took a look at it from every angle, and I didn't think that this application would present an issue that the Malowitzes have expressed. I think shadow is a factor that the board can consider. I think that what we're proposing is an increase of 5 feet, which is not a substantial change in the height of this structure. We already have an existing ridge running east to west in this location, so I don't think that there's going to be a significant difference in the shadowing, in the effective
What
shadowing.
time were you there, Attorney Cloud?
I was there at about 2:30 today.
Where was the sun with respect to the shadowing concern?
Well, it was behind the clouds this afternoon. But I have a pretty good idea of where the sun typically is this time of year. And of course, it changes over the seasons. In the summer months, you're going to be skewed more to the south. In the winter months, you'll be sorry, I reversed that. In the summer months, you'll be skewed more to the north, and in the winter months, you'll be skewed more to the south. Shadow is something that changes over time, depending on season, depending on time of day. But I don't think that what the applicants have proposed is going to constitute a substantial difference in the effect of it.
And for the record, there has been no dialogue between the applicant and the abutter?
Apparently not.
Or with you?
No.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. All right, anything else from the board?
No, could we discuss it for a bit?
Certainly can.
So my biggest concern is that they had originally, again, on the original permit, and I know that Mr. Clower is coming in after the fact, but this was specifically permitted within the guidelines we're allowed to permit, and the changes that occurred went over those guidelines. So when a neighbor comes up and says, I spoke at the last meeting and they said there's really nothing they could do, I probably agree that there wasn't, because they kept them within the lot coverages that were allowed. Yet what was constructed and what was added to it went over those coverages, lot coverages and by structure. We hear a lot of complaints, over time about issues with shadow, and every project is different, but it is not very difficult to do a very quick shadow study with an architect, and I'm sure this builder has an architect on staff. And I think when there's a concern of a neighbor where there's been a house that's been built in excess of the original permit, I don't think it unreasonable to ask an applicant to come back with a shadow study showing exactly where the new additions are. I do think they should try to reduce whatever coverages they can to either meet or come as close as they can to whatever the original decision was. I am glad that they got rid of that cobble entry in front, and then as far as everything else, you'd have to go through a board of selectmen. So I would like to see them come back with what they may reduce on the plan to try to go back towards the original coverages. I know that Mr. Clower said he thinks it might be the bins or something else on there, maybe that's something they could fool with. But I think in lieu of the comments tonight, that we should ask, it's very easy to do a very quick shadow study. It doesn't take long, it's not a significant cost. And I think that's something that the board should request.
Tend to agree with you, Bob. How does the rest of the board feel?
I agree.
All right. So we would be looking at a continuance for the applicant to perform a shadow study and then try to reduce.
Try to come more in compliance with the original permit.
Sure. One thing I'd like to point out, just, I haven't taken a look at anything beyond the aerial photographs, but buildings that have been in existence for more than 10 years do become legally non-conforming. So I don't know whether or not that is the case here. That's something we can look to figure out.
That's an option that you have, but again,
I completely.
You know what I understand.
I completely understand.
In lieu of the situation of a neighbor that came to the original hearing and was basically informed that, it was gonna be within whatever the guidelines, and now they find out it's not within the guidelines, that see if the owner is willing to.
Yep, I will certainly speak with my client.
Appreciate it, Attorney Clower. And what do we have?
May 12th.
May 12th?
So then I would make a motion to continue this hearing to May 12th?
All right, motion to continue May
Just put a
12th.
reason on it?
No, we're gonna
On the
continue.
motion?
He understands that, what we're looking for, a shadow study and a
Shadow study,
reduction of.
possible reduction. And
Second.
that's all. All right, so motion was made by Bob, second by Scott Peterson. All those in favor? Aye.
Thank you very much.
Thank you. All right, we do have open meeting items.
Chairman, I'll move to continue the board's business
Oh,
for
that's
10
right.
minutes.
Okay,
That keeps it
10 more minutes made by James. Is there a second?
Traditionally second it.
So, noted. Thank you, Scott. All those in favor?
Aye.
Aye. We're going on for 10 more minutes. Voting the minutes of February 24th, March 10th, and March 24th.
And we're just tabling March 24th.
All right, so February 24th, has everyone had a chance to review?
Yes.
Anyone like to make a motion?
Motion to accept minutes of February 24th.
All right, motion was made by Bob. Is there a second?
Second.
Second by Scott Peterson. All those in favor?
Aye.
Aye, passes. March 10th.
Motion to approve minutes of March 10th.
Motion was made by Bob. Is there a second?
I'll do it.
Second by Scott Zelinski. All those in favor?
Aye.
Aye, passes unanimously. And tabling March 24th. Board update. So this is something that came in this afternoon. I didn't really have a chance to review it and address it. But with the new town council, I suppose, comes new opinions. And we received something regarding, well, I'll have Noreen email it out to everyone, but I just want to address it now. There is a State Ethics Commission advisory voting on matters affecting abutting or nearby properties. Briefly, it says in the State Ethics Commission states that an appointed employee should not take any official action in connection on a matter that affects property that abuts their own. And that does include abutters who are on those legal lists within 300 feet. It says in the alternative, the abutting board member may seek and obtain an exception from the appointing authority, in this case would be the select board. The select board will then decide whether to grant the exemption. So if a member has a conflict of interest, it's incumbent upon that member to understand their own rights and obligations under the law and take the appropriate action. So that is slightly different than what we're used to. I think it is different because you're dealing with abutting properties or nearby properties. It's not quite, disclosing a personal relationship or a financial interest. So that very well be the difference with the opinion. So, Noreen, if you could send that out to everyone, that way we're all caught up to speed and we can
So in that case, what we
make
do-
disclosures or recusals
Would we disclose, so
appropriately.
we'd still submit to the administrator, and then would you submit to the
Right,
select
but
board, or
I
we would just
think,
send it directly to them?
yeah, but I think the sort of difference here is instead of a disclosure the night of the meeting, if you intend to participate,
In
the
advance.
intent is that you would get approval from the select board as the appointing authority
They'll make the
in
decision.
advance. Yep,
Because it's not a happenstance thing, you know.
right.
You know where you live, so it's not like you recognize somebody in the audience.
Exactly.
Sometimes you don't read the mail.
Sometimes you don't. So everyone just be cognizant of that. Board discussion, is there anything? Future, sorry, Brian?
No, so I guess Jerry brought up at the beginning of the meeting, so my nomination was accepted to the Finance Committee at town meeting.
Congratulations.
Thanks. I've gone through town management, town council, David Vieira, and also the chairman of the Finance Committee. So because the Finance Committee doesn't meet on a regular basis, they won't even be meeting, and next meeting will be September. So they're deferring any resignation that I need up until September, when I would actually have to participate and become part of the committee. I may leave prior to September, but I probably won't know that until later in the year.
All right.
And if you don't get elected, you don't have to worry.
No. There's more complications than you
Oh, I can,
shake a stick at.
All right, anything else for board discussion? Future agenda items. All right, our next hearing is April 21st here at Town Hall. Meeting adjourned.